Waiting on the live stream. Live stream is up. PC recording started.
All recording and rolling.
Thank you. Good morning, everyone. Welcome to today's remote New York City Council hearing of the Committee on Civil and Human Rights. At this time, would all panelists please turn on your videos for verification purposes. To minimize disruption, please place electronic devices to vibrate or silent. If you wish to submit testimony, you may send it to testimony@council.nyc.gov. Again, that's testimony@council.nyc.gov. Thank you for your cooperation. Chair Williams, we are ready to begin.
Good morning. My name is Natasha Williams, and I'm the chair of the Civil and Human Rights Committee. Thank you for joining our virtual hearing today on the New York City Commission on Human Rights Complaint Processing Times and Resolutions. Before we begin, I would like to acknowledge my colleagues who have joined us today, Councilmember Marte, Stevens, and Farias. Although this hearing has been overshadowed by Intro 134, today's oversight topic is a very important one as it examines a process that is integral to the work of the New York City Commission on Human Rights. The commission is dedicated not only to educating New Yorkers on their rights and obligations under the city's human rights law, but also protecting them from discrimination and hate. Receiving and processing complaints is crucial to ensuring that New Yorkers have recourse in the face of discrimination while serving in its role to protect the rights of New Yorkers. CCHR has seen major growth in inquiries alleging discrimination, especially in recent years. The commission has seen the number of inquiries received double over the course of 5 years, with 5,296 inquiries in 2015 compared to 10,015 in 2020. As of fiscal year 2021, the commission has reported a total of 9,983 inquiries. During this hearing, the committee seeks to learn more about how the commission processes such a large volume of inquiries, as well as how and why different types of inquiries receive certain outcomes and resolutions. The committee is also interested in hearing whether CCHR's processing time can be improved and how. Additionally, the committee will also hear Intro 134 in relation to employers required to post minimum and maximum salary information. I'd like to thank Speaker Adams and her leadership for allowing for ample time to have true deliberation on this important legislative matter. On December 2nd, 2021, the committee heard a bill now known as Local Law 32 in relation to prohibiting employers from posting job listings without minimum and maximum salary information. Testimony and feedback received during and after the hearing has informed the amendments that Intro 134 seeks to make to the original law. I also want to assure everyone that I am interested in hearing all sides and amenable to changes pending the testimonies of today's hearing. I'd also like to note that while Local Law 32 is one step in the right direction towards pay equity, we still need to do more, and it is not the only provision that will resolve pay equity in its entirety. I'd like to thank committee staff, Jay Surrey, senior counsel to the committee, William, a policy analyst, Jack Kern, our financial analyst, and of course, my wonderful staff, Everton Smith and Ashley Meza. I will now turn it over to the committee counsel.
Thank you, Chair Williams. I'm Jace Regan-Apathy, and I'm committee counsel to the Committee on Civil Human Rights, and I will be moderating this hearing. Before we begin, I would like to remind everyone that you will be on mute until you are called on to testify, at which point you will be unmuted by the host. During the hearing, I will be calling on panelists to testify. Please listen for your name to be called, as I will periodically be announcing who the next panelists will be. At this hearing, we will first be inviting testimony from the Department of Civil and Human Rights, and then from members of the public. During the hearing, if council members would like to ask a question of the administration or a specific panelist, please use the Zoom raise hand function and I will call on you in order. For all panelists, when called to testify, please state your name and the organization you represent, if any. We will now call on representatives of the administration to testify. We will be hearing testimony from Joanne Camiff Ward, Deputy Commissioner of Policy and External Affairs at the New York City Commission on Human Rights, and Sapna Raj, Deputy Commissioner of the Law Enforcement Bureau at the New York City Council on Human Rights. We will also be joined for questions by Catherine Greenberg, Special Counsel at the New York City Commission on Human Rights. At this time, I will administer the affirmation. Panelists, please raise your right hands. Do you affirm to tell the truth, the whole truth, and nothing but the truth before this committee, and to respond honestly to council member questions? Deputy Commissioner Ward?
I do.
Deputy Commissioner Raj?
I do.
And Special Counsel Greenberg?
I do.
Thank you. At this time, I'd like to invite Deputy Commissioner Ward to present their testimony. And I would just like to acknowledge that Speaker Adams has joined us. Deputy Commissioner Ward.
Good morning, Chair Williams and members of the Committee on Civil and Human Rights, Speaker and other council members that have joined as well. I'm Joanne Camiff Ward, the Deputy Commissioner of Policy and External Affairs at the New York City Commission on Human Rights. And it's my pleasure to join you today to testify regarding Intro 134, which would amend the city's administrative code to require certain employers to post salary-related information on job advertisements. As Jayshree noted, I'm joined today by my colleagues, Deputy Commissioner of the Law Enforcement Bureau, Sapna Raj, and Special Counsel Catherine Greenberg. Last month at this committee's preliminary budget hearing on the commission, we had the opportunity to speak in depth about the breadth of the commission's work across New York City. And today I will give just a brief overview before we turn to the substance. The commission is the local civil rights enforcement agency that implements the New York City human rights law, which is one of the broadest and most protective anti-discrimination laws in the country, with 27 protected categories, and which covers housing, employment, and public accommodations. By statute, the commission has two main functions. First, the commission's Law Enforcement Bureau enforces the city human rights law by investigating complaints, initiating its own investigations, and utilizing testing to help identify violations of the law, all of which my colleague Sapna Raj will discuss in her testimony. Second, through the Community Relations Bureau, the Commission provides workshops and trainings on New Yorkers' rights and the obligations of businesses, employers, and housing providers under the City Human Rights Law. And we work closely with community partners and sibling agencies in these efforts. 7 years ago, the Commission established the Office of the Chair, which houses the agency's policy, legislative, rulemaking, and adjudicatory function. And this is the office in the Commission where I sit. So this morning, I will start with a discussion of the human rights law's employment protections as context for discussion of both Local Law 32 and Intro 134, and then I will turn it over to Sapna. So since 2015, the New York City human rights law has been amended by the City Council 38 times. More than a dozen of these amendments are in the area of employment, which is also the area where we see some of the highest numbers of filed complaints. And I want to note some of the significant amendments in the employment arena to contextualize our conversation. So a number of the human rights law expansions from the past 7 years relate to language that appears in job advertisements and which require employers to take specific steps in hiring to comply with the human rights law. Today, the city human rights law prohibits discrimination on the basis of criminal history, which means that employers can't include language such as no felonies or criminal background check required in job advertisements. The fair chance protections in our law also limit when in hiring employers can ask about criminal history. And where employers make an inquiry, they are required to seek information from applicants themselves and to conduct a balancing test that they then share with an individual if they choose not to hire them after conducting a criminal background check. The law further prohibits discrimination on the basis of credit score, which includes prohibiting employers from using language such as credit check required in job advertisements. Our human rights law also contains one of the nation's first bans on salary history inquiries, which prevents employers from asking any questions during interviews or in job applications about prior earnings and benefits. And lastly, the law ensures that the rights of pregnant and nursing people in employment, including requiring employers to designate spaces for employees to express milk and to create written policies regarding lactation accommodations. Each of these amendments that I've mentioned apply to employers with 4 or more employees. There are some provisions of the human rights law that apply more broadly to all employers, even those with only 1 employee. That includes prohibitions on sexual harassment, as well as newly instituted protections for domestic workers in employment. But most protections apply to employers with 4 or more employees. Because the New York City human rights law's coverage is broader in many and most instances than federal law, which generally covers only employers with 15 or more or 20 or more employees, our law provides vital protections for hundreds of thousands of New York City workers who otherwise would have little recourse against discrimination or retaliation at work. So with that background, I'll turn to the subject of today's hearing, Intro 134. In December, as has already been mentioned, there was a hearing on what was then Intro 1208 on salary transparency. And I testified in front of City Council about pay equity, speaking in support of the intent of what is now Local Law 32, which requires covered employers to include a salary range in job advertisements. Local Law 32 is currently slated to go into effect in May of this year, May 15th. To assist employers in complying with this new provision, the Commission has developed a fact sheet on Local Law 32 and also begun outreach. Our publicly available fact sheet, which can be found on our website, explains that when employers advertise a job that will be performed in New York City, they have to include a good faith wage range. Here, good faith means the range that the employer honestly believes they're willing to pay at the time that they post a position. And as our fact sheet indicates, the term salary refers to the base rate of pay, be it hourly, annually, or paid at any other frequency. The fact sheet further clarifies that salary does not include other benefits or incentives that may be part of a compensation package. That can include things like a commission, tip, bonuses, or stocks. In addition to developing written materials, the Commission is getting the word out to potential employers and employees about job posting requirements as part of our outreach and education mandate. So Commission staff have already been speaking with business owners and attorneys about these new protections. Earlier this month, the Commission presented at a workplace compliance consortium, and we're joining several more trainings this month, including one for attorneys this afternoon and one in a few weeks alongside the Department of Consumer and Workplace Protections. And I should underscore that we endeavor to speak with business owners and potential employees at every opportunity, with the real goal of fostering compliance with the human rights law in order to advance equity for all New Yorkers. In addition to the work that we've been doing, there's been significant public interest and media coverage of Local Law 32 to date. This includes legal alerts and trade publications. Forbes magazine has covered the salary transparency law twice since December. There was a recent piece in Newsweek, and my colleagues have spoken on CBS segments as well. Looking ahead, the Commission plans to ensure comprehensive outreach in the business corridors in each borough and to collaborate with chambers of commerce and bids, as well as professional associations, to share information on salary transparency legislation. And that's if we stay with Local Law 32 or if the law is ultimately amended, as we're discussing today. Any new protections will be built into our human rights law training, and information will be shared at the resource fairs and roundtables our agency attends, pathways in which we engage with tens of thousands of New Yorkers annually. In our outreach, we plan to collaborate with small business services, along with other government partners, as we have done in several instances in the last several years. As the City Council contemplates Intro 134, which amends Local Law 32, the Commission again offers wholehearted support for measures that advance pay equity, including efforts to foster transparency in hiring and other measures that level the playing field for employees and aim to tackle existing disparities. This is consistent with our mission and our commitment to ensure that all New Yorkers can live and work with dignity, free from all forms of discrimination, and our commitment to advancing racial and gender equity more broadly. The Commission believes that laws and policies that intentionally seek to eradicate the root causes of discrimination and inequity are pivotal. Each of us have seen or personally experienced discrimination that is overt and intentional. However, every day, discrimination occurs as a result of practices and policies that disproportionately disadvantage particular individuals and groups. In the employment context, hiring practices that may seem neutral on their face can perpetuate and even exacerbate inequity. Discrimination in pay or in the terms of employment can be difficult to detect, as employees are often hesitant to share salary information with colleagues and often do not realize or are unable to find out that they are being compensated at lower rates for comparable work. Recognizing this reality, local and state governments across the country, including in New York, are taking steps to advance pay equity. Salary transparency is one of the tools that can level the playing field for employees and for women and people of color and other New Yorkers who've historically been and continue to be harmed by wage disparities. Wages are important because they can be determinative of quality of life. They define what's affordable for us in the short term, and they can impact the ability of individuals and families to accrue intergenerational wealth. So actions taken to address pay inequity today can yield long-term benefits. This is an issue that the Commission has long been focused on. In 2019, the Commission convened a public hearing on pay equity alongside the Commission on Gender Equity and the Department of Consumer and Worker Protection. This hearing and all of our work in this area have emphasized that federal, state, and local legislative and policy changes are needed to foster fairness and equity. That hearing in 2019 underscored a range of recommendations to address disparities in wages, which include the need for increased transparency surrounding pay, one of which is to post salary ranges. Additionally, there was support for employer reporting of pay data and demographic information, as well as periodic audits that can be publicized. Testimony in the 2019 hearing also suggested that there's a need for greater services and supports for individuals that have been most impacted by wage disparities and underpayment. And that included measures such as raising the minimum wage, expansion of access to affordable childcare, as well as outreach and training programs that enhance career development and workplace readiness. The Commission looks forward to work with this City Council as well as sibling agencies and relevant stakeholders, many of whom are here today, to promote gender and racial equity and advance pay equity in New York City. Thank you again for the opportunity to speak today. My colleagues and I look forward to continuing to discuss Intro 134 and to working with you to ensure that New Yorkers can thrive. And it's now my pleasure to turn the floor over to Deputy Commissioner Sapna Raj to talk about the Commission's innovative law enforcement work.
Deputy Commissioner, before you go, I just want to acknowledge that we have been joined by Speaker Adams, Councilmember Brewer, Councilmember Joseph, and Minority Whip Vernikoff.
Thank you. Good morning, Chair Williams and members of the Committee on Civil and Human Rights. I'm Sapna Raj, Deputy Commissioner of the Law Enforcement Bureau at the New York City Commission on Human Rights. It's my pleasure to speak about the work of the Law Enforcement Bureau. The attorneys in the Law Enforcement Bureau evaluate and investigate allegations of discrimination brought to the Commission by members of the public and utilize the agency's investigatory and prosecutorial powers to root out pattern and practice or other forms of discrimination through Commission-initiated investigations. LEB, which is the Law Enforcement Bureau, and its specialized units, the Early Intervention Unit, the Source of Income Unit, and Gender-Based Harassment Unit, offer the option of resolving claims in lieu of filing a complaint, leading to quicker resolutions. Resolutions through the pre-complaint intervention have significantly increased over the past several years, as LEB has worked to provide timely resolutions despite an increased caseload. In fiscal year 21, the Commission fielded 9,055 inquiries from members of the public in the form of phone calls, emails, letters, visits to the Commission offices, and queries to mobile intake units dispatched to community sites or at Commission events. The Law Enforcement Bureau uses a variety of tools to investigate and determine whether violations of the human rights law have occurred and to provide redress. We are an enforcement agency, but we do not simply issue determinations that violations have occurred and that damages should be paid to the complainant or that civil penalties should be paid to the City of New York. Our aim is always to repair harms experienced by individuals and communities impacted by discrimination and to prevent future human rights law violations. The Commission takes a cooperative approach to fostering human rights law compliance. In many instances involving first-time violators of the city human rights law, where no complainant was harmed by a violation, the Commission has sought to educate businesses and housing providers about their legal obligations and work with them in creating non-discriminatory policies and practices rather than levying fines. The Commission has several pathways to identifying violations of the human rights law. Any individual can contact the Law Enforcement Bureau via our info line to report allegations of discrimination and to file an individual complaint. Any New Yorker has the right to file a complaint with the Commission in the jurisdictional areas covered by our law. The Law Enforcement Bureau may also become aware of alleged unlawful discriminatory practices through an anonymous tip, information shared by a community-based organization, an elected official, through social media or media reports. In these instances, the Commission can launch a Commission-initiated action. The Law Enforcement Bureau also uses testing as an investigative tool to determine whether there is discrimination in housing, employment, or public accommodations. The agency has the authority to use testers to determine if they are treated differently or given different information by potential employers, landlords, real estate brokers, restaurants, hospitals, stores, or other public accommodations because they belong to a protected class. This is a historically effective tool used in civil rights litigation. When the Commission learns of potential discriminatory conduct through a tip, testing, or a complaint filed by a member of the public, the Law Enforcement Bureau has many options as to how to proceed. The Commission has the authority to take a range of actions before a complaint is ever filed. One is to issue a cease and desist letter to notify the alleged wrongdoer that actions taken may be a violation of the New York City human rights law, demand the discriminatory actions cease and that specific actions be taken, including, for example, restoring the victim of discrimination to the status they were in before the discriminatory action or change policies and procedures. While cease and desist letters can be very effective, the Commission uses a suite of investigative methods, such as requests for information on policies and practices, demands for documents and data, and interviews of key witnesses to build a comprehensive record of what occurred. Each of these tools can help build a factual record. The amount of time that it takes to respond and investigate depends on the unique factors of each case: the underlying claim, the factual and legal complexity, the availability and responsiveness of those harmed by discrimination, as well as any witnesses and respondents. Ultimately, at the conclusion of an investigation, the Law Enforcement Bureau reaches a determination as to whether the evidence it gathered supports the allegations in the complaint or not. If the Law Enforcement Bureau finds probable cause, the cases proceed to a hearing at oath, presided over by an administrative law judge. Before initiating the prosecution, the Law Enforcement Bureau attempts to settle or conciliate the case. If the case does not settle, then oath will hold a hearing, and the commissioner of the Commission on Human Rights will issue a final decision dismissing the case or ordering relief for the complainant. At all points during the investigation, once probable cause has been found and until a decision and order is issued by the commissioner, the parties can and do enter into settlement of the claims. Not all complaints are resolved by a law enforcement bureau determination on the merits. Many cases settle for monetary restitution and or affirmative relief such as policy creation, training, monitoring of the covered entity's business practices or community service. In fiscal year 21, 30% of cases were resolved through settlements. It is important to note that not all inquiries become file complaints. The Commission has instituted a range of approaches to quickly resolve matters. In the ongoing effort to foster accountability and justice for New Yorkers facing ongoing discrimination and harassment, the Law Enforcement Bureau has increasingly pursued pre-complaint interventions. This is where the Commission attempts to resolve claims prior to the filing of a complaint. In fiscal year 21, the Law Enforcement Bureau obtained a positive outcome for a complainant in 214 matters, such as a reasonable accommodation for a disability or a transfer away from a harasser without filing a complaint. In fiscal year 20, the Law Enforcement Bureau resolved 403 matters in this way. In fiscal year 21, the most common pre-complaint interventions involved disability accommodations in housing and lawful source of income discrimination in which a tenant or prospective tenant was denied an apartment or the renewal of a lease based on the use of rental assistance. Because of LEB's interventions, New Yorkers were able to get a ramp installed at their apartment building or have the employer grant reasonable accommodations that was requested due to a disability, pregnancy, or religious beliefs without filing a complaint and ensuing a litigation process, which can be lengthy. The Law Enforcement Bureau remains a venue for justice where recoveries and affirmative relief are calibrated to address the harms caused to New Yorkers. Through conciliation and decisions and orders, the Commission can award monetary damages for the complainant, including lost wages, emotional distress damages, and attorney's fees. The Law Enforcement Bureau can also impose civil penalties of up to $250,000 that are paid to the general fund of the City of New York. Since 2015, the Commission has broken records year after year with respect to damages and penalties assessed. Last year was no different. In fiscal year 21, the Commission recovered $9,741,000 in compensatory damages and civil penalties, the highest in Commission history for the third year in a row, and $2.2 million more than fiscal year 20. Of that, $8,069,000 were awarded in compensatory damages to complainants and $1,678,000 in civil penalties to the general fund of the City of New York. In addition to securing monetary relief, the Law Enforcement Bureau continues to innovate creative resolutions that deter future harm and put restorative justice principles into practice to change the dynamics that led to harms in the first place. Through case resolutions, the Commission can order respondents to perform wide-ranging affirmative relief, including posting notice of rights the Commission has issued, creating or revising policies, conducting trainings, performing community service, and more. Settlements and agreements usually involve some combination of policy changes, training for staff and management, civil penalties, posting requirements, or other forms of affirmative relief. In instances of employment discrimination, the Commission has negotiated resolutions that require respondents to invest in employment pipeline opportunities for underrepresented groups and to engage with community-based organizations to facilitate broader recruitment. In housing cases, settlements have included set-asides of apartments for voucher holders and broker incentives for working with voucher holders. The Law Enforcement Bureau continues to identify strategic interventions to address discrimination in housing, employment, and public accommodations, and to respond to retaliation. We look forward to working with the administration and members of the City Council to identify and root out all manifestations of discrimination and harassment. Thank you for convening today's hearing today. We look forward to your questions. Thank you.
Thank you. I will now turn it over to questions from Chair Williams. Panelists, please stay unmuted if possible during this question and answer period. Thank you. Chair Williams, you may begin your questions.
Thank you. So I will start with the complaints process and results. One of the primary functions of CCHR is the intake, processing, investigation, and determination of complaints. This process includes several steps and each case will be unique. I also want to mention the quality of an investigation is very important. In the first 4 months of fiscal 2022, there were 105 complaints filed and 253 closed. Additionally, the average age of a complaint was 447 days. Does this mean that of the open complaints, the average number of days those cases have been open is 447?
Yes, that means that the cases were open for that period of time on average. So some cases, depending on the complexity of the case, some cases will remain open longer because an investigation involves filing up the complaint, filing an answer by the respondent, filing up a rebuttal, submitting a rebuttal by the complainant, investigating further by getting documents and data and interviews of witnesses. So all of that can take a long time depending on the complexity of the case, how many witnesses are involved, what the data is like, and how many documents are involved. Yes.
Okay. What is CCHR's goal for the time it takes CCHR to complete an investigation?
Again, I think it depends on the case. I don't think we can say that in general that a case should take only X amount of time. We try to resolve our cases as promptly as possible. However, depending on the complexity of the case and the parties involved, cases can take longer and cases can take a much shorter period of time. So some cases close in a very short period of time, and others take much longer for the investigation to be completed.
Okay. Can you please describe the process of a complaint? I know you mentioned there's investigations and a series of things that take place from an incident to its determination from CCHR. What is the life cycle of a case?
So, yeah, sure. So if a complainant comes forward and wants to file a complaint and is jurisdictional, we will draft the complaint. The complaint is then reviewed by the complainant and signed and notarized. All of that can take a little bit of time, depending on the complainants. Sometimes it's hard to get in touch with the complainant and have them sign the document. Once a complaint is filed and served on the respondent has 30 days to respond and file an answer and a position statement. In law, in litigation, usually there is a period of time when people get extensions of time in order to do that. Once they have filed the answer and position statement, the complainant has a chance to submit a rebuttal. Once that rebuttal has been submitted, then we start the investigation by asking for documents and information policies, data, and names of witnesses that we may want to interview. We also interview the respondents. And once during this whole process, at any point in the process, the case can settle. So sometimes we are involved in settlement negotiations at the same time that we are doing the investigation. So once the investigation is complete, then we determine whether we will find probable cause or not. If we find probable cause, that case can still settle, but can be referred to oath. Once it's referred to oath, there is a hearing, a settlement conference, then there is a hearing scheduled. Once the hearing is held, then the ALJ, the administrative law judge, issues a report and recommendation. That report and recommendation comes back to the commissioner, the chair of the commission, who issues the decision and order.
Okay. What parts of the process do you feel take the longest amount of time? Is it in the responses or is it in just the investigative work?
I think that also depends on the case and who is involved. Sometimes it takes a long time to get complainants to respond. It takes a long time to get respondents to respond. Other times that happens quickly, but the investigation takes longer because there's a lot of information we are looking for. We want to make sure the investigations are as thorough as possible so that we reach the right determination. Whether we decide to find that there is no probable cause, that we are going to administratively close the case, we want to settle the case because we think there are issues that show that there's some liability, or whether we want to refer it to oath. So I think it's hard to say where that it always is one or the other. It depends on the case, what takes longest.
Okay. Would you say that additional staff in your particular unit will decrease the time it takes to complete an investigation, or is this something that cannot be changed from staffing?
I think we always welcome more staff. I think I'm very, very proud of the Law Enforcement Bureau and the work that we've done. Despite the pandemic, despite all the other issues that we've had, that we are able to process the complaints and we are able to find justice for New Yorkers as promptly as possible. But I think no one's going to say no to having more staff.
Got it. What is the current total caseload of CCHR?
So I think on average, the attorneys have about 70 cases that they are handling at any one time.
No, what's the total though? Because that's the average caseload per attorney, but what's the total number of cases?
I don't know exactly how many cases we have currently pending. I can always look into that and update you.
Okay. Yes, we would love to know how many cases in total. I have a few more questions. CCHR mediates some complaints through the Free and Voluntary Mediation Office from fiscal 2019 through fiscal 2021. Annually, the average number of complaints successfully mediated is 42. In that same time, maybe someone can mute. Awesome. CCHR has had 3-year average for filing 653 complaints annually. This would be approximately 6% of opened complaints resulting in a successful mediation. Can you please describe the mediation process, and has the feedback on the mediation process been positive?
Do you want to answer that, Joanne, or do you want me to?
I'm unmuting myself. Fine for you to answer. I think I just wanted to clarify, mediation is actually separate than law enforcement. That Sapna intimately knows the process, so I think that's really fine, Sapna.
So I can just talk about how, I will say in the beginning to start that the mediation process has received, our mediation process has received, I would say, 5-star reviews. People have been amazingly impressed by how well our one mediator has handled mediations that have been referred to her. The Law Enforcement Bureau refers cases where both parties are represented, and we think that a mediation would be a better process than either investigating the case further, or we think, in our assessment, or whether it goes to oath.
Okay. So in reference to what you just said, how do you prefer mediation as an outcome of a complaint? So when you receive a complaint, how do you determine which complaint should seek mediation? How is it prioritized in the process of a complaint?
I am going to have Catherine Greenberg, who handles our mediation referrals, to respond to this. Catherine?
Yes, thank you. So our mediation program, we choose cases where we feel there's a lot of investigative work still yet to be done before we would be ready to reach a determination, where both parties have made compelling allegations and we want to give them an opportunity to try and negotiate a resolution among themselves before the Bureau really digs in to gather the evidence we would need to reach a determination. So it's typically cases that are early in the process that get referred, where we've served the complaint, gotten a response, and where the parties are interested in trying to resolve the matter with the facilitation of a mediator before we begin an active investigation.
Okay, switching gears a little bit, the most common outcome of a complaint is administrative cause, where CCHR finds dismissal appropriate due to the inability to locate a complainant, repeated failure of a complainant to appear at meetings, unwillingness to provide information, attend a hearing, and other items. This accounted for 48% of closed complaints in fiscal 2021. Why do you think that so many cases are closed under administrative causes?
So there are many reasons under administrative closures that we would close a case, not only because we are not able to get in touch with the complainant, but we have completed the investigation and we think that there is not going to be a finding of probable cause. Once we close the case as administratively closed, what we call an AC, the complainant, if they want to come forward, can of course appeal that to the office of the chair, or they can file in state court for for another 3 years. So that actually, we find that a better solution than or determination than finding of no probable cause.
Okay, are there any other new challenges in relations to complaints or processing that CCHR has confronted due to the COVID-19 pandemic?
Well, I will say that the number of complaints decreased during the pandemic because of the eviction moratorium, because people were not at work, and also because a lot of the public accommodation places of public accommodation were closed to the public. We're seeing an increase now that those things have changed and the city is opening up.
Okay, staying with the COVID-19 theme, how much discrimination testing has CCHR conducted as a part of its enforcement efforts since the onset of the COVID-19 pandemic?
So we have, you mean just the testing itself?
Yep.
I have that right here. So in 2021, we completed 1,422 testing of entities tested. In 2021, we completed 878. And I think to date in fiscal year 2022, we have about 400 tests.
Okay, and what about like pre-COVID? Because 2020 was like the COVID year, everything shut down in March. So do you have any numbers from like 2019 or 2018 to sort of compare the testing conducted before COVID-19?
I do, and I can actually get that to you, council member, but I will say that even though we were in a pandemic, the testing continued on a robust regimen. We did most of our testing. We weren't doing any in-person testing because we weren't sending our testers out into the city to do in-person testing, but we did most of our testing by telephone and then online. And we were able to complete quite a number of tests, not as many. It kind of reduced a little bit from 2020 to 2021. And also in 2022, but I think we are picking up the pace at this point.
Okay, I will actually pause there and open it up to my colleagues for questions in relation to complaints, process, and results before we ask questions in reference to Intro 134. All right, no questions. Okay, thank you, Deputy Commissioner. We look forward to following up with you to get the numbers and some of the other metrics we asked during this hearing. And now I will focus my attention to testimony by Deputy Commissioner Joanne regarding Intro 134. So Deputy Commissioner, does CCHR foresee any difficulties in enforcing the amendments found in Intro 134?
Hi, thank you for the question and thank you all for your time. I think it's always difficult to anticipate exactly what enforcement will look like before a law goes into effect, right? The transition from paper to practice. And in Intro 134, I mean, before this amendment, we were gearing up to start enforcing local law 32, and a major component of that work, right, is letting people know about the change in the law. So education is the first step to realizing our ultimate goal of compliance with the human rights law. I think one piece that we see as the commission that is very helpful in terms of both outreach and education and enforcement is clarity in the law. And consistency of who is covered by our law, be it in the employment context, in housing, or in public accommodations. And as I noted in my testimony, the majority of the provisions of our law apply to businesses with 4 or more employees, and we believe it's a strength that there's clarity in the protections that employers have. So that is one piece that I will flag between local law 32 and local law 134. The other piece that I would flag is also related to this point on clarity of protections and requirements, relates to what actually employers are required to put in their job advertisements. And that, if you look at the text of local law 32 and our fact sheet, and as I said in the testimony as well, we've defined salary to be the base rate of pay or the base wage, regardless of the frequency of that payment. Intro 134, I think, adds in some new language that appears to go further in terms of what is required for employers to include by referencing compensation, which if we look to federal law and other state law as well, compensation is more comprehensive than salary and can include bonuses, tips, stocks, and many other factors. So I think in terms of enforcement, we would like to ensure clarity in what is required by City Council for employers. But I will turn it over to my colleague, Catherine Greenberg, to see if she has anything to add.
Can we unmute?
She's saying no. She's saying no. So next question.
Okay.
Yes, no, thank you.
Okay, as a follow-up to what you just said, and I know there's been a lot of conversation around the number of employees. Are you aware of the city's administrative code and its definition around micro businesses?
Micro businesses, the 15 it's either 19 or 15 or more. So yes, I'm aware of it, but I have not read it recently.
Okay, because I think, you know, part of the intentions around the bill is to have, of course, a special carve out for small businesses. And there are definitions in different parts of the law, of course, not in your law, that sort of define the number of employees based off of their sort of makeup as a micro business or a small business. So just wondering if you all thought through that. Okay, so how will CCHR use the 6-month extension of the efficacy date to make changes and conduct outreach to ensure compliance? Can you unmute Deputy Commissioner Joanne, please? Thank you.
I look forward to these hearings being in person. But in terms of thinking through enforcement, and I think I referenced this a little bit already, the commission is always, as Deputy Commissioner Raj indicated, interested in a cooperative approach and in fostering compliance. So we work very closely. We have a community relations bureau, which actually has an office in each of the 5 boroughs and works with chambers of commerce and bids on a regular basis to literally pound the pavement in communities and to do business corridor outreach. And that's something that we would certainly leverage between this point in time and either the May effective date, or if there's an amendment enacted into the November date. So we will be in communities spreading the word. Obviously, we have a fact sheet that we can disseminate, but we also will include information on this law and all the trainings and outreach that we do, which is the mandate of the Community Relations Bureau. I think I alluded to this in my testimony, but you know, last year in August and September, when key to NYC, the city's vaccine mandate was put into place, our commission was called upon to help small business owners understand their obligations and how to comply with key to NYC. We worked very closely with small business services, with the mayor's office of nightlife, with DCWP, and with other community partners to spread the word. And that's exactly what we would do for this protection as well.
Okay, I know in the budget testimony, I think for me, what came out of it is the fact that CCHR is severely under-resourced, right? That's like a fact. Maybe you all can't sort of say that. I know you all have to work with OMB, but it is clear that CCHR could use more resources. And so just wanting to understand sort of how you'll allocate resources to conduct outreach, because I know outreach has been a concern in regards to what you said, the fact that the lovely council that I'm now a part of has amended your law 38 times, and each time that the law is amended, of course, we then instruct the agency to do all of this work, you know, but don't necessarily attach all of our amendments to resources for you to actually do the work to the highest quality. So just wanting to understand with the PEGs, with such budget constraints that you are already under, how you envision sort of shifting resources to accommodate both outreach and enforcement of the existing law.
Thank you. It's a great question. And I think I have to start by echoing what Sapna said, which is that we would always welcome more resources as an agency. And we are a small agency, and there have been many amendments to our law, but I think we are very proud of the fact that with each of these amendments, we have been able to either pivot in the short term, in our policy work, for example, to ensure that we are focused on getting the word out, to use our communications team to ensure that we are getting the word out in as many languages as possible, to as many both employers and potential employees as possible. And so we welcome support, but we are confident that with the staff and the resources that we have, we will be able to get the word out effectively. And that's because we're able to leverage community partnerships and sibling agencies and city council. I mean, we partner a lot in doing outtake and education and outreach. So thank you all for the work you do with us.
Before I ask my next question, I just wanted to acknowledge Councilmember Krishnan and Lewis, who have joined us today. So did the commission interpret local law 32 to apply to jobs that could be performed outside of New York City? Oh, can you unmute Deputy Commissioner?
Yes, there's just a slight delay. So we talked a little bit about the importance of consistency and clarity in protections, and that same theme applies to the application of our law in the employment context. So the general way that our law has been approached is really a single unified understanding that our law applies where the impact of discrimination is felt. So that in this context, if a job would be undertaken in whole or in part in New York, and that is known at the time of the posting, then an employer would need to comply with the human rights law.
Okay, did the commission interpret local law 32 to apply to general notices that an employee is hiring, such as a help wanted sign? If not, does CCHR find the clarification in intro 134 to be helpful?
Thank you. So we do, a written advertisement is defined in our fact sheet, our interpretation of local law 32 to date, to say that when you are posting and there are known positions, you would be required as an employer, if you fall within the covered set of employers, to include a salary range. And that would include a help wanted poster. In response to the second question, I am a bit concerned that the carve out, which I understand conceptually, has the potential to swallow the rule. So there's the potential that an employer can just have an open, we will be hiring, or we are hiring, and they might know the salary range, but they can use the potential carve out to evade having to include a salary range. But we would be keen to talk to City Council and the stakeholders on this call and elsewhere to think about how do we ensure that we are finding the right balance between the potential burden on employers and covered entities under our law and protecting the rights of New Yorkers to advance pay equity.
Okay, and I guess in that same vein, do you anticipate that larger employees will use general advertisements to avoid compliance with the law?
I think I generally operate from a position of good faith. And I see, as we've seen these types of law pass in other jurisdictions, we've seen general compliance. And I would hope that for all the reasons people support pay transparency and leveling the playing field, that employers who may even be covered by the law in other jurisdictions would do their best, and as the law requires, put in a good faith effort to include the knowledge that they have about their ability to pay potential employees in job advertisements. So I will go with, I'm hoping for the best, and we are prepared in the event that folks are not working in good faith. Thank you.
Got it. So the fact sheet that you mentioned, is that the official guidance that CCHR has put out? I know there was something online, and if so, what informed the guidance?
Sure, these are great questions. That is our interpretation of local law 32. Obviously, if the law is amended along the lines of intro 134, we would go back to that guidance and update it. And that guidance was informed by a few things. One, by a review of our own existing protections and case law, interpretations of our law and how it has been applied by courts, as well as conversations with stakeholders, which include business groups and include advocates who have been working towards salary transparency. And I mentioned in my testimony that we have been working with sibling agencies on pay equity for several years, and many of those actors are people that we consult with on a regular basis. And I should flag, we are also always open to feedback. That's from now until any effective date and after the effective date, right? Our goal is always for our materials to be clear and helpful and informed by what's happening in practice as well as in the legal system.
Thank you. So I will pause again to open it up for questions from any of my colleagues who are currently on the call, on the Zoom, on the hearing. No hand.
Chair, we don't see any hands raised. Actually, I see we have Councilmember Joseph has her hand raised. Councilmember Joseph?
Hi, good morning, everyone. Good morning, Chair. Thank you for this very important conversation. Thank you, everyone. I just wanted to ask a quick question concerning businesses. How would it impact businesses that are already small businesses? How would it impact it? And how do we support them, especially coming back from COVID? No? You guys can hear me, yes. Okay.
Yes, we can hear you. It's that it takes me a minute to catch up and unmute myself.
No worries.
So, I think as I mentioned in my testimony, our law applies, many provisions of our law already apply to small businesses, and we are well aware that this is a new requirement. And our focus in the coming months, and that's including after the law goes into effect, right? We don't do education and then have enforcement. Education is an ongoing part of our mandate. So we will be consistently working with small business owners, chambers of commerce and bids to explain what the law means. And we understand that we are asking, or City Council in this legislation is asking small businesses to add something to job advertisements. I think often employers have a sense of the universe in which they are able to afford employees, and this law is really asking them to share that information. And as we discussed previously, it's about a good faith salary range. So it's at the time of posting, what do you think you're able to pay? It doesn't prohibit employers from being able to offer something different if they find a candidate that they think is fantastic and is more qualified than they ever imagined, or if their financial circumstances change, that the ultimate amount that is paid is less than what's in the range. I think the intent here is really about leveling the playing field and ensuring that potential employees have a sense of whether it makes sense to move forward applying for a job. Is it potentially a good fit? And asking employers to put one of their cards on the table during the hiring process.
Okay, thank you. Thank you. And you said that education comes first, right? You educate the small business owners and then you roll it out, and is this also being provided in different languages as well?
Okay, yes. So as a threshold matter, we translate our materials, our core materials, into 10 languages at least. But with protections like this, we also look at what is the universe of business owners? What are languages that might be helpful, even if it's not required for our agency to publish something in that language? How are we going to reach the most people? And a huge asset on our staff is not only that we do written materials in a range of languages, but we have staff on our community relations team that speak more than 20 languages and lead advisors and liaisons across the city in each borough and with relationships in a variety of communities. So we will leverage that humongous asset in our outreach. Our trainings are also done in multiple languages, and So it's speaking, writing, and being able to respond to inquiries that we receive in the languages that are accessible to the New Yorkers that need to know information on the human rights law.
Wonderful. Thank you so much. Thank you, Chair.
Thank you, Councilmember Joseph. We have Councilmember Brewer's hand raised. Councilmember Brewer, if you'd like to go ahead.
Thank you very much. I've tried to listen. There's a lot going on in the office right now, but I tried to listen. I think it's a good law that Helen Rosenthal passed, and I think there are people who think it should stay the same, and then there are people who think that local law or intro number 134 should be instituted. So my question to you is, I guess you're not taking a position. What you're stating is that you're going to enforce whatever law comes along. I think that's sort of what you're saying. But my question is, do you have any opinion on this? What's going on, guys? Do you have any opinion on this? Or is there, even having passed the basic date myself, I know how complicated these things can be. So my question is, when you answered the question about New York versus not New York, in terms of many of these companies go, as you know, nationally, not to mention internationally, and also the size of the employer. What is your experience about whether this law should or should not, this intro should or should not be passed? Do you have an opinion?
There are many different pieces of it, and which influence my answer to that question. I think in terms of the effective date and what we've been hearing from folks on this call, we are very open to ensuring, again, our goal is compliance with the laws that we enforce. And as an agency, we are committed to continuing expansive protections for all employees in New York. So I think the law that gets human rights protections to the most people possible, while also recognizing there's a balance of employer needs and actions that we're asking businesses to take, or that this law will ask businesses to take, is something that requires ongoing conversation. I stated, I think before, Councilwoman Brewer, that we see a value in clarity and consistency. So ensuring that the provisions of our law, to the extent possible, apply equitably to businesses, and then that can be known in a fairly concise and clear way to sophisticated businesses, unsophisticated businesses, and everyday New Yorkers who will benefit ideally from the protection of this law.
Okay, I mean, that means understandably, I understand what I understand what you're saying. It's just not that you're doing what I said, which is you're going to pass, you're going to enforce, I'm sure equitably, because the commission has always done that, but not taking a position. Can you just clarify one more time how you handle, because this is an issue with all of your challenges, those businesses that have borders beyond the city of New York. How do you handle something like that? Because so many of them do.
Sure. So I did want to clarify that the one piece where I think we have a strong position is having clarity in the drafting on what employers are required to include in the job postings. And so the current Intro 134 includes legally defined terms that are compensation and salary, and so clarifying what the intent of City Council is. And obviously we work with the law department and committee council and other stakeholders between this hearing and the eventual discussion of what law is passed. But those are pieces that I just wanted to flag. And I'm going to, I think my colleague Catherine Greenberg, I'm going to pivot to you on the question of looking at employers that are in multiple jurisdictions.
Yes, of course. So the focus of our law in terms of where it applies has to do with the specific job itself, because as Deputy Commissioner Ward had said before, it's where the impact of the discrimination is. And so that's typically going to be where the work is being performed. So an employer who has a brick and mortar location in the 5 boroughs, and that's where their employees work, they are covered by the law, and all of their employees who work at their brick and mortar location have the protections of the law. For an employer who's based outside of New York City, it would only be employees who are performing work within the 5 boroughs, only those positions that would come under the New York City human rights law.
Okay, and I assume, paid sick days is the same thing. I assume you have a definition, because you can work here and Connecticut and here and Australia. But I assume you have a definition that precedes this discussion. Correct?
Yes, council member. Yes, council member. So that definition is uniform across the entire city human rights law and for housing providers and public accommodations as well. But this is a definition that's understood by employers, by their council, by business groups, so that they can have a consistent understanding of which provisions of the law would apply to them.
Okay, I'm still a little confused, Madam Chair, but I'll yield to somebody else, to be honest with you.
Thank you, Councilmember Brewer. We have Councilmember Farias with her question.
Hi, good morning, everyone. Thank you for testifying. I just wanted to ask a follow-up clarity question around remote work and hybrid work. What we've seen post-pandemic or throughout the pandemic is employers have had to adapt and their employees have had to shift quite a bit to either keep their jobs or keep the level of hours that they need to make the wages that they're given. How is that under the law right now in terms of remote and hybrid work?
So I'm actually going to turn this one back over to Catherine, because I think it's a continuation of the point that she was just making.
Thank you.
Thank you very much, and thank you for the question. And it's an excellent question that we've been hearing a lot of as the way people work evolves. So currently, the city's human rights law, all of the employment protections apply to people who are performing their jobs in New York City, whether they're working in an office, working in the field, doing sales, or whether they're working from their home remotely. So in this context, and all of the city human rights law's protections that apply to hiring, if the employer is going to be hiring somebody who works from New York City, including working remotely, then the protections of the law would apply to that person and the requirements of the law would apply to the employer. So if an employer is going to be posting a job that can be performed remotely from New York City, they would be expected to comply with our law, as is the case with many other laws across the country.
Okay, great. Thank you for that clarification.
Thank you, Councilmember. Chair Williams, I don't see any other hands raised. If you'd like to go ahead.
I just have one more question, because we didn't talk about the fines, which I think is really high for a very small business. And so just wanted to know your thoughts on the fines and whether or not it would be appropriate to potentially create a cap for small businesses around the fines. Again, we've had a lot of conversation about the number of employees and understand exactly what you mean in terms of previous laws and a threshold that you all have used. And so just wondering, what your thoughts are on the fines. Because you said something that I thought was interesting about a delicate dance and making sure that, of course, we're not being overly punitive, but at the same time, wanting to protect workers.
Sure. So I will just give a brief response and then I'll turn it over to the experts on enforcement, which are Deputy Commissioner Righ and Special Counsel Greenberg. I want to underscore here, first off, that we are not an agency that walks around looking for violations or issues really fines alone. I think Sapna Raj talked through the approach that we take, and there are many tools in our toolbox before we get to the step of fines and fees. And one of those is just letting business owners know if a potential violation comes to our attention what the requirements of our law are, and providing for a cure period through something called a cease and desist letter. So I think in many instances that would be an approach that we would take, but there's a number of factors that we have used in looking at enforcement for the employment protections I've already mentioned. So I'll turn it over to Sapna to respond more fulsomely.
Thank you, Joanne. So I think one thing we should remember is that the fines that we're talking about, the $250,000, is a maximum. That is, it's very rare that we have imposed that. I would say that the time that I remember that we've imposed that large a fine was in the settlement that we had with Fox News, which was a sexual harassment commission-initiated matter, and we had assessed $250,000 per violation, and it was $1 million settlement. That's extremely rare. The maximum is $250,000. We look at the size and sophistication of the business. We look at the violation, as Joanne said, and I've said before in this today. We also look to make sure that policies and practices are changed. And a lot of times we will look at that in order to determine what the fine needs to be, civil penalties need to be. So it isn't a blanket fine of $250,000. It's a ceiling, and it's not a floor.
Thank you so much, Deputy Commissioners, for your testimony. I look forward to working with you to address these very important concerns for New Yorkers.
Councilmember Chair, we do have a question from Councilmember Faria.
Oh, sure.
Sorry, thank you, Chair, for allowing me one more follow-up, because that was a great question. Can I just quickly get the minimum? Do we have an estimate of what a minimum of a fine would be for a small business, roughly, if there's an estimation? And then the follow-up also is, what do we have the time period for curing for a small business that's typically utilized?
So, go ahead. I mean, not just in this particular case, and not just with this particular legislation, but in all of our protected categories, there is no minimum. There are a lot of cases, if you look at our website and our settlements page, you'll see that a lot of cases are settled without a fine. It can be just affirmative relief, where the respondent changes their policies and practices, gets training, does postings, maybe they do community work, but we don't always assess a fine. And we don't always assess damages either. It all depends on the case, the complexity, what kind of respondent it is, and what the facts are in each case.
That's great to hear. So we're already protecting small businesses as it is in this. Great. And the cure, is there like a minimum or a cure period? Like, is it 30 days, 60 days, 90 days, or is this also case by case?
That's also a case by case, on a case by case basis. There isn't necessarily a cure period. We are looking to make sure that the businesses comply with the law, know about the law, and change their policies and practices. So there's not always a cure period.
Awesome. Thank you so much for my follow-up and today's testimony from all three of you.
Thank you, Councilmember. I'll now turn it back over to Chair Williams for any additional questions.
Nope, we can move to the next panel. Just want to thank the administration again.
Thank you. We will now turn to public testimony. I'd like to remind everyone that unlike our typical council hearings, we will be calling on individuals one by one to testify. Each panelist will be given 2 minutes to speak. Please begin once the sergeant has started the timer. Council members who have questions for a particular panelist should use the raise hand function in Zoom, and I will call on you after the panelist has completed their testimony. Council members do have at most 5 minutes for any additional questions. For panelists, once your name is called, a member of our staff will unmute you and the Sergeant at Arms will give you the go-ahead to begin on setting the timer. Please wait for the Sergeant to announce that you may begin before delivering your testimony. I would now like to welcome Senator Jessica Ramos to testify. After Senator Ramos, I will be calling on Winston Tokuhisa and then Charisma White to testify. Senator Ramos, you can go ahead when the sergeants call time.
Time starts now.
Well, buenos dias. My name is Jessica Ramos. I represent Senate District 13, which includes Corona, East Elmhurst, Jackson Heights, and parts of Astoria, Elmhurst, and Woodside in Queens. I also chair the Senate Committee on Labor, and like many of you on the City Council, bring my experience working in service of my neighbors and the labor movement to my position as a legislator. In the labor movement, we know the best answer to the question of guaranteed pay equity is a collective bargaining agreement. Until that time, where every worker has the ability to negotiate through a collective voice and on even footing with their employer, we have a role to play as lawmakers to address pay disparity that discriminates based on race, gender, or any class. I don't need to review the horrible statistics that outline the reality of racial and gender-based pay discrimination with you. The City Council acknowledged the importance of pay transparency as a path to closing pay gaps when you passed Local Law 32. You already know how this deeply entrenched issue impacts women of color across sectors. Instead, I testify before you today to share the concerns of the labor movement and raise my own concerns with elements of the recently introduced Intro 134, which on its face effectively weakens the ability of Local Law 32 to meet its goals. I want to thank Councilmember Williams for graciously making the time to discuss our shared goals of supporting small businesses and MWBEs while addressing pay disparity. And I remain open and available to collaborate and ensure the strongest possible outcome is achieved. First, language in Intro 134 defines a small business as one of 15 or fewer employees, rather than the threshold of 4 employees codified in the state human rights law. There should be consistency across the city and state, and the threshold that exempts a business from posting their wages should only be permitted to businesses with 4 or fewer employees. Offices with fewer than 15 employees can still be highly profitable and open to practices of pay discrimination. The implied argument with a carve out for small businesses, however you define them, is that they should have the opportunity to engage in opaque and discriminatory hiring practices. Whether you are a micro business or a startup, pay discrimination should not be a tool at your disposal to scale your business. This is an implication we must reject and instead look to give support to even our smallest businesses with other legislative tools. Second, the exemption for general notices that an employer is hiring without reference to a particular position creates a loophole for companies of all sizes to avoid compliance and transparency. I cannot foresee what the purpose of this exemption would be other than to create a venue for employers of all sizes to attempt to recruit talent without having to disclose the wage they intend to pay. By creating unnecessary ambiguity, this provision is likely to be used by employers to avoid compliance and risks swallowing the entire law. I will close by saying that I carry a complementary bill to Local Law 32 in the State Senate with my counterpart Assembly Labor Chair Latoya Joyner. S5598B would mandate that employers disclose compensation or range of compensation upon announcement of a job opportunity and would provide the State Department of Labor with improved enforcement capacity. By enhancing transparency around compensation at the start of the hiring process and limiting the role of employer bias, this bill will empower applicants with critical information, prevent wage discrimination, reduce negative negotiation outcomes, and address systemic gender-based wage disparities that originate during the hiring process. I look forward to our continued partnership as we work at every level of government to ensure that as people return to work after the pandemic, they have the ability to earn equal pay for equal work. Thank you for your time.
Thank you, Senator Ramos. I would now like to welcome Winston Tokuhisa to testify. After Winston Tokuhisa, we will be calling on Charisma White, followed by Keisha Kemp. Winston, you can go ahead when the sergeants call time.
Time starts now.
Ever since I first became homeless in 2006, I've repeatedly been robbed in the very worst way imaginable. Not in the conventional sense with regard to money or property, I'd say that it has not happened, but worse still, of the best years of my life. It's not lost on me that had the New York City Commission on Human Rights, System of Income Discrimination, or CID unit been funded appropriately, I could have saved at least a few. It was only by chance that a city councilman's office referred me to the health search training conducted by the then Partnership for the Homeless and Neighbors Together. Through them, I learned how to find apartments to voucher, what my rights were, and how the city unit could assist me. Little did I know even this knowledge in isolation would not be enough to get me housed. In January 2019, I documented and filed a complaint for my first GUID experience before being introduced to the CCHR investigator assigned to my case. Previously, I had heard stories of ideal scenarios where an intervention took place and voucher holders were placed in an apartment they wanted or a comfortable one. Unfortunately, I was not so lucky. While the investigator was encouraging, by June, she was no longer with the organization. This change was seemingly innocuous, only marked the beginning of the end. In the subsequent months, contact with each side investigator became less and less frequent until it stopped completely. The last I heard, I may have some money coming to me as an outcome of the trial, but who can say? It's unfortunate that this vital unit which gives hope to the hopeless has been worn down from party of 6 to one sole member. And as a friend I told this to said, that highly qualified as a unit, it's more like Uno. For far too long, the most vulnerable of your neighbors, together with myself, have gotten a raw deal. I hope you take it upon yourselves to make it right by ensuring no less than $1 million is allocated to fund the New York City Commission on Human Rights' Source of Income Discrimination FID unit. Thank you.
Thank you, Winston. I would like to now welcome Charisma White to testify. After Charisma White, I will be calling on Keisha Kemp, followed by Francilia Wilkins. Charisma, you can go ahead when the sergeants call time.
It starts now.
Hello, my name is Charisma White. I am an advocate for homeless New Yorkers throughout the 5 boroughs. It took me around 3 years to get a lawyer from the Cchr. The process source of income discrimination against me and helped me get the apartment that I am in now. During those 3 years, I was homeless. My landlord is currently trying to evict me with a family of 3. I'm in the process of looking for a new place to live, and it's taken me over a year to find a new apartment. I'm working with the Cchr, but they are not responding fast enough for me to find a new home for my family and me. When the commission does not respond in a timely manner, it leaves people like me homeless. The only lawyer in the SID unit that I have been working with to try and help me get housed is leaving Friday. That was last Friday. If I don't have a mediator from the Cchr to help me get a viewing with landlords that don't respond to me, I'm left with nothing. It is critical that the source of income discrimination unit at Cchr gets its funding that it needs. In fiscal year 2023, Cchr should be funded at a baseline of $1 million to meet this critical need. Thank you for your time.
Thank you. As a reminder, if any council members have questions, you can use the Zoom raise hand function. I would like to now welcome Keisha Kemp to testify. After Keisha Kemp, we will be calling on Francilia Wilkins, followed by Frank Curbine. Keisha, you can go ahead when the sergeants call time.
Time starts now.
Hello, my name is Keisha Kemp. I was in possession of a city pets voucher while I was in NYCC apartment in Brooklyn, New York. The landlords were not accepting my voucher. I reached out to Cchr and I heard back from them roughly 90 days later. This is unacceptable. In my experience, the city agency completely dropped the ball. I currently am in a shelter and need the advocacy of the Cchr to help me to get into a stable and safe housing? How is it possible that I have to wait for months for a callback from CCHR? With CCHR's help, I could get out of the shelter system. I need CCHR to respond to my calls promptly to get out of the shelter system. We have to do what is right and get more funding for CCHR. In the fiscal year 2023, CCHR should be funded at a baseline of $1 million. I would appreciate whatever advocacy you can provide for all services rendered and needed and necessary for this time of need. It's not just for myself, it's for all those who are in the same sort of situation that myself is in. Thank you.
Thank you for your testimony. And yes, I will assure you that I have been advocating to increase the funding to ensure that the source of income unit can properly enforce and help New Yorkers who are facing discrimination, voucher discrimination. So thank you so much for your testimony.
Thank you.
Thank you. I do not see Francilia Wilkins or Frank Curbine in our panelists. The next witness we will call would be Kathy Wild. Following Kathy Wild, we will be calling on Margaret Price and then Andrea Johnson. Kathy, you can go ahead when the sergeant's call time.
Time starts now.
Thank you. I'm joining with the 5 borough chambers of commerce and many other representatives of both small business and large business to express our thanks to the council for being willing to consider our comments, which we were not able to make during the original consideration of local law 32 because there just wasn't the opportunity. I think that the key to this, to understanding the importance of the amendments, which we support, is to understand the conditions both post-pandemic and in general in New York City for small business at this time, and also for our global nature of our city's workforce, which means that we have jobs here in New York City that are very important to protect pay parity, equity, and also, but we also have positions that are in other jurisdictions around the world. And it's the clarity that businesses are looking for, make sure that we're.
What do you want me to say? Anything you need to know goes through me first. Like
IHRA. Visit www.nycc.gov/access.
I think everybody was unmuted, so we need to mute everybody back.
Okay.
Yes.
So, as you know, small business particularly lost a lot during the pandemic. We also have very restrictive immigration policies, part of them because of the COVID-19, part of them because of the national policies that cut back on international availability of talent. Today, we have 200,000 plus job opening postings every day in the city. So we have a very tight talent market, and employers generally are anxious to support pay equity laws, but we think that the time to inform businesses of this law, and also this law applies to nonprofits, the time to inform them just isn't there, and to educate them on compliance. It's also important to note, in terms of the burden on small businesses, that these enforcement of these laws under the human rights law are complaint driven and all subject to private rights of action, and that this involves expenses that small businesses are not accustomed to. We've found that businesses with under 15 employees, many of them, in fact, a large majority of them are a combination of immigrant and minority MWBE businesses. So those businesses in particular, it takes time to reach out for them. So we particularly appreciate the pushback in the effective date of this law, so there's time to educate them. And we're also looking for the opportunity for employers to be able to participate in making this law work, because it's in all of our interests to have an effective law. So thank you for this opportunity and for the consideration that you're providing.
Thank you, Kathy. Chair, it looks like we do have a question from Councilmember Brewer, followed by Councilmember Farias. Councilmember Brewer, if you'd like to go ahead.
Time starts now.
Thank you very much. My question is, what specifically in the proposed intro do you think would be helpful for clarity? What are specifics? Is it the 15? Is it the international? What is it that you think would help clarify the situation? And
Number
why?
one, push back the date so that employers have time, especially this is small employers, nonprofit and business in education. For big employers who follow these things and have law firms that follow them, it's more an issue of being able to figure out how they're going to communicate to their current employees what they're doing, how they're going to reevaluate what their salary ranges are, and make sure they just need time to make sure that what they're doing in terms of their New York City employees, how that applies to their global situation and how their existing workforce sees these new job postings. So that's number one. And then I think that the other important thing is the clarification with regard to that this applies to New York City jobs, whether they're remote or the job definition is somebody can be working from home, but they're still working in a New York City job. And I think that was not clear in the original legislation. I think the Human Rights Commission has attempted to make that more clear, but that's very important to us.
Thank you.
Thank you, Councilmember Brewer. Councilmember Farias, you can go ahead.
Time
Thank
starts
you.
now.
Thank you. I just have some clarifying questions around the testimony or the memorandum you sent around earlier. I understand the date and pushback. I agree in order to give folks time to kind of get accommodated and actually present how the equitable salary ranges they would like to pay Black and Brown people in communities or low-wage workers. We should allow them time to do that. But do we feel like a competitive market isn't good for small businesses? In terms of hearing your testimony, we have like unprecedented competition for qualified Black and Brown folks. The
point of that, Councilmember, the point of that point, both on the talent shortage that we have in the city right now, with a lot of jobs that are not filled because we haven't focused enough on upskilling our own people, and we've cut off international immigration, and so global talent is not flowing into the city as it has under more generous immigration policies. So we've got that set of issues that employers are facing right now. With regard to diversity, which has become an important value, and this is with large employers I'm talking about, there's really a premium in certain jobs that you want to pay to get more senior people of color. So it's not necessarily going to fall within the same job category. It's not been clear to us whether someone who doesn't apply for a job and then you end up with the maximum salary of that job being more than what was advertised, is there litigation potential there where an employer can be sued because they pay more for a candidate? For example, a hospital that has to recruit somebody from out of state and pay more to get a licensed professional because they've got a shortage of talent. For a diversity candidate that an employer is going to pay more to because they're trying to meet that value, their DEI values. So that's a question, because New York is a very litigious place. Anything you do in terms of adding new provisions to the Human Rights Commission, all this stuff is complaint driven. That's enforcement in this area. So this is an invitation to lawsuits. And that's the concern that both large and small business have.
Yeah, see, I just, for me as a Afro-Latina, a woman of color, a young person in workforce, both who has worked in the nonprofit sector, both in city government and now as someone as a boss or employer in some facet for a team of people, I think we are losing people because we're not paying Black and brown people, immigrant people, women, young people, the salaries that they deserve. I personally, over years of interviewing for a lot of different sectors or a lot of different titles, have wasted my time going through multiple interviews and reaching to the end point where the salary range was not suitable for my value and my experience. And so I can't fully understand how we have an issue here where we should be protecting workers and ensuring that people in our communities can actually apply for the jobs that they're qualified for. I think we're looking out and outsourcing jobs because the people that we have in our neighborhoods are refusing to work for the places for low wage work that isn't of the same value that they have willing to offer. And personally, and I'll let you speak and I just want to wrap this thought up, is company culture matters. If you're creating an environment that's welcoming and that's open and that's willing to pay people for their value and their skill set and experience, I believe that they will work for your employment or for your company, even if it's maybe a little bit less than what they're willing to do because they feel welcomed and they feel like it's an environment where they want to work and be able to thrive in. So for me, salary ranges, I'm just having a very difficult time understanding why we are hyper focused on 15 or less employers, the people that are actually supposed to be employing the people in my community, to make sure that they can actually stay here when we're fighting gentrification, when we're looking at recovery, when we're fighting for higher wages. We have folks in sectors right now that are asking to increase our minimum wage. And here we are fighting to balance out the field and be able to not have people waste their time interviewing employers that do not want to pay them the salary range that they deserve.
I agree with you on all those points. I don't think the law addresses those points. I think if you were consulting with employers on how to frame a law that addresses those points, it would be one that actually measured results, not one that was simply putting a salary range in a job posting. That doesn't guarantee anybody anything.
We can agree to disagree right there. And I don't have any more time left. Thank you, Chair, for letting me go over.
Thank you, Council Member. Seeing no other questions, I would like to now invite Margaret Price to testify, followed by Andrea Johnson, and then Myrble Regan. Margaret, you can go ahead when the sergeant's call time.
Time starts now.
Thank you very much for allowing me to speak. I am author of the book Single Women and Money, published by Roman and Littlefield. I'm also co-chair of Manhattan's Community Board 8 Women and Families Committee. At our Women and Families Committee meeting, March 30th, the committee overwhelmingly passed a resolution strongly opposing the proposed Int 134, which would diminish the value of the upcoming salary transparency law. Women in New York State are paid a median 86 cents for every dollar a man typically earns. The salary transparency law takes a significant step toward closing this harmful, discriminatory wage gap. That the City Council would even consider diminishing a law that would help end wage discrimination is unfortunate. Moreover, the City Council should not be considering legislation that would bar employees in smaller businesses from the worker protections available to employees in larger businesses. We also believe that New York's employers, by now should be well prepared to comply with the salary transparency law by May 15th. Thus, CB8's Women and Families Committee strongly opposes the Amendment 134, and we urge the City Council to oppose it as well. Thank you very much.
I just want to state that I don't think that this bill intends to erase salary equity. I understand what the concerns are and have spoken offline before this hearing and really are listening to all of the things that are being brought up today. But I think we need to be careful about using certain language that's not really intended with the bill or even baked in some of the changes. So I just wanted to note that.
Am I allowed to respond?
If you want.
No, we believe that any diminishing of the salary transparency law would be most unfortunate, especially for the thousands and thousands of workers in small businesses who would not therefore be able to benefit from the law that you so smartly passed back in December.
I didn't pass the law. I wasn't in the council then, but I understand what you're saying. And I thank you very much for your testimony.
Thank you.
Thank you. I would like to now call Andrea Johnson, followed by Myrble Regan, and followed by Julia Elmali Sachs. Andrea, you can go ahead when the sergeants call time.
The time starts now.
Thank you. Andrea Johnson with the National Women's Law Center, and I'm here to express our concerns with INT 134. The Law Center has been working for decades with elected officials across the country to pass laws that will help close gender and racial wage gaps. And we're seeing right now that salary range transparency is a top policy priority and a trend that we're seeing really sweep the country, because research shows time and again that providing applicants the salary range for a position helps narrow gender wage gaps. There is a direct correlation there and narrows those gender wage gaps that otherwise can arise in negotiation. And in just the last year, we've seen 4 states, Washington, Rhode Island, Connecticut, and Nevada, pass laws requiring employers to provide job applicants the salary range for a position at some point in the hiring process. We're also seeing more and more businesses, small and large alike, voluntarily implement salary range transparency, not only because it helps employers avoid wage gaps and litigation, but because small businesses have told us it helps them more efficiently and effectively find and match with interested candidates and avoid wasting time interviewing people who aren't interested. And indeed, a recent study found that the number of job postings that include salary ranges has been on the rise this year, given the increasingly tight labor market. Colorado's salary range posting requirement, like New York City's, applies to all size employers. Actually, applies to all size employers. I understand that your original law applies to those with 4 or more employers. But Colorado's law applied to all employers because this information is important no matter where you work, and it is a simple measure to implement. Employers know from their own budgeting what they're generally able to offer for a position. This just says be transparent about that. So thank you for your consideration of my testimony, and I'm happy to answer questions.
Thank you, Andrea. Seeing no questions, I will now call on Myrble Regan, followed by Julia Elmali Sachs, and then Amelia Adams. Myrble, you can go ahead when the sergeants call time.
The time starts now.
Good morning. My name is Myrble Regan. I have worked along with many others for 50 years to help more than 25,000 New York City women and working families to prepare for better jobs, college, and business ownership. Yet, this is our reality today. It will be in my written testimony. I am here because of these and other statistics on behalf of women, people of color, and all those who work hard every day to make New York City a great place to live and work for all of us. The proposed amendments, Intro 134, may seem like small and innocuous corrections. Please don't believe it. Read it carefully and you will see that it has the real potential to water the original bill down to almost nothing. It actually provides gigantic loopholes that some employers will indeed use to completely circumvent the intent of New York City's salary transparency bill. Please stay on the side of New York City workers as together we take further steps toward pay equity and transparency. Please take the time to decide what amendments or clarifications, if needed, might actually make the salary transparency bill better protect New York City workers. If you want to be better informed about this proposed amendment, go to the Power New York website for more information. My written testimony provides information about the Women's Center for Education and Career Advancement and our recent research defining exactly how much income working New Yorkers need to support their families. Thank you to the committee chair, Natasha Williams, and the committee members for this opportunity to testify today. Please feel welcome to contact me for further information.
Thank you, Marble. I will now call on Julia O'Malley-Sachs, followed by Amelia Adams and Barbara Kushner. Julia, you can go ahead when the sergeant's call time.
Time starts now.
Thank you. Good morning. My name is Julia O'Malley-Sachs, and I'm a plaintiff side employment attorney at Kermiller PC. In December 2021, I sat before the New York City Council to testify in support of the latest salary transparency bill, which was later signed into law with broad support from plaintiffs' attorneys and other workers' advocates. It requires employers in New York City with 4 or more employees to post the minimum and maximum salary when advertising a job, promotion, or transfer opportunity. Its purpose is crystal clear: to close the wage gap for women and people of color by promoting transparency around hiring and compensation. Today, I sit before this City Council once again to testify on behalf of NELA New York, the New York affiliate of the National Employment Lawyers Association, working with PowHer New York. And to be frank, I am disturbed. Disturbed that this City Council is considering walking back the city's salary transparency law, a law that represents a historic win for workers in the fight against workplace discrimination before it has even taken effect. The amendments proposed today not only undermine the purpose of the law by creating exemptions for wide swaths of employers across the 5 boroughs, it perpetuates systemic inequities against the very people who were meant to benefit from this law, women and people of color. As attorneys for employees, we frequently represent workers who are subjected to all kinds of discriminatory abuse by their supervisors. This misconduct sometimes includes wage discrimination. Too often, women and people of color are paid less than their colleagues who are performing substantially similar work. This is nothing new. For years, workers' rights activists have used the hashtag Equal Pay Day to call attention to the wage gap. In 2022, women in the US earned just 83 cents on the dollar compared to men on average, according to the National Committee on Pay Equity. The figures are even more bleak for women of color: 75 cents for Asian American, Native Hawaiian and Pacific Islander women, 58 cents for Black women, 50 cents for Indigenous women, and just 49 cents for Latino women. New York City's salary transparency law aims to shrink these wage gaps by requiring employers to be more transparent around compensation. But Intro 134 threatens to set a dangerous precedent for those seeking to chip away at the anti-discrimination protections afforded by the city's human rights law. First, the bill limits the definition of employer to include only those with 15 or more employees, a significant departure from the original threshold of 4 or more employees. As many today will explain in greater detail, this carve-out for certain small businesses risks opening Pandora's box for corporate interests to create additional loopholes that would help companies avoid compliance with the city's anti-discrimination law. In
Ms.
addition,
O'Malley-Sachs, time has expired.
oh, I'm sorry.
I have a
I
question.
Sure.
Yeah, so can you, and this is for anybody that was on that panel, can you explain how this would prevent pay equity?
Absolutely. Many of the city's employers have 14 or less employees, and by not being required to post salary ranges, those employees that may apply to those jobs will not know what their counterparts are making. So that's one of the ways that it would not promote salary transparency and equity. And another way, which I was about to speak of when my time ran out, is that the exception for remote work is a really big exception. Now with the pandemic, so many of us, as you know, are working remotely. And an employer could say that their job posting prefers in-person work or remote work, which would allow them to not post a salary range. So all of those potential employees that might apply to that job will not know what the salary range, will not know what their male counterparts or white counterparts might be making at work for those jobs.
I don't, and maybe committee counsel, if I'm wrong, please chime in, but I don't think that this bill actually gets to one of the roots that you're talking about in terms of knowing what you just said, white counterparts. And I don't think the bill, there's no way to know what a white person is making at a company through the salary ranges being on a job description, unless we're doing something else. Because how would you know unless a company is completely disclosing all of the salaries, which this bill does not do. This bill is focused on job descriptions. And I understand what you're saying. And I actually think that is like the larger issue when you actually get into a company and like actually seeing what the salaries are. This bill is in reference to job descriptions. So if you could share like how one would ascertain what the different salaries are within a company through this legislation, because that I don't understand that point.
I'm happy to respond, but I'm also happy to allow others who have their hands raised to respond.
Sorry, you can't unmute Andrea.
Thank you so much, Chair, for that question. So there has been research showing that in negotiations, it is common for wage gaps to arise at that point because a few factors. One being that women tend to ask for less than men, even when equally qualified. And I think there's sort of internalized bias that is at play there. But research does show that when women have the context about a negotiation, what is negotiable in the salary range for that position, that information helps close those wage gaps. And I can include citations to that in my written testimony to show that. So this is a major tool that has been identified by the equal pay community as crucial to closing gender and racial wage gaps that otherwise arise in negotiations.
No, I understand that part, but the comment that was made was that we would be able to see what our counterparts are making, right? So if the focus is women, because I think the focus seems to just be women. I know people of color being tossed in and out of the conversation, but it seems the focus seems to be women, which I understand. And the comment was that we would be able to see what other people are making, and I don't really understand how we would be able to see what people are making if this is specific to the job description. There's no way to see what people are making internally. And that was the comment that Julia, I believe you made.
Can I respond?
Sure.
Thank you, Chair Williams. I believe the law as it stands right now also applies to promotions and transfers. So that would, for people who are already working at a company and would like to have a promotion or a transfer opportunity, that would apply to their counterparts that are, already at that promotion level as well. They would at least know a salary range and be able to know whether they're making the same amount of money.
I get what you're saying. I think we can move on because I don't want to sort of expound upon this point, but you made a statement that we would then be able to see what everybody in a company is making. And this law doesn't do that. It's really to a particular job description. Now, I get the argument that it helps with salary negotiations, and actually randomly, this article actually fell on my lap. I was looking at a news listserv that I'm on, and it was crazy. I just happened to be looking at my emails last night, and it was about, the title is "What Salary Transparency Won't Solve for Women." And in the article, and not that I agree or disagree with this article, but in the article, one of the things that they pointed out is really in the negotiations, it's really when we talk about bonuses and other incentives where we see the most pay inequities. in jobs. And so, and even you just said it yourself, a part of pay transparency, which I agree with you, I agree with all of the testimonies that it does sort of chip away at pay equity, because it allows for transparency around how much a particular person would make if they apply to a said job, and they can use that information to negotiate for a higher salary, understanding what those minimum and maximum salaries are. But it's just the notion that, you know, all of a sudden, you know, pay equity will be solved and we would know what everyone is making within a particular company through this legislation, and that the legislation doesn't do that. And so I just want to make that point, but we can go to the next person, J3.
Thank you, Chair Williams. I would like to now call on Amelia Adams to testify, followed by Barbara Kushner, and then Tim Johnson. Amelia, you can go ahead when the sergeants call time.
Your time starts now.
Hi, good afternoon, and thank you. Oh, thank you, Chair Williams, for this opportunity. I don't know if anyone can see me because I just see oh, it's my timer. So sorry. I am testifying on behalf of me as a business owner. I run a consulting firm, Adams Advisors, and I actually welcome the changes that Chair Williams has proposed. And I think two of them are that I kind of want to harp on is that in talking to other fellow business owners around the original data implementation, a number of folks were just not aware. And I think there were some good questions that other council members brought up around like outreach, education, but I also was just shocked at one of the comments that in the testimony, an admin talking about advertising and Forbes. And I just think that is so removed from where everyday businesses are at getting information from and such things. I've submitted, and I'm going to be submitting more testimony and memos in support of these changes for small business owners who welcome this, like more time to actually get their house in order. Because I know that, you know, as a small Black woman-owned business, we are often overlooked for many things, grants, RFPs, and I think my time is running out, sorry. We're often looked over on a lot of things, and having this cutoff where, you know, I originally wasn't originally cut off, but this new change with 15 employees or more, I wouldn't be covered. And I think that I pay a decent salary and benefits and things like that. But compared to larger firms, if you put side by side positions that I'm advertising and positions that other firms are putting at, I may be seen as a non-desired workplace because my salary study range is not as high, and I yield my time.
Thank you, Ms. Adams. I would like to now call on Barbara Kushner to testify, followed by Tim Johnson, and then Jessica Walker. Barbara, you can start when the sergeants call time.
Time starts now.
Thank you, and thank you, Chair Williams. As a woman of color and the owner of an MWBE business, I'm an advocate for gender and racial pay parity. I started my own company out of frustration with the discriminatory treatment of Black women in the workforce. So I applaud the City Council's concern with addressing this issue and seeking to achieve racial and gender equity in compensation practices. At the same time, I do not believe that a law that requires employers to list minimum and maximum salaries in a job posting is a solution to the pay parity issue. In fact, for an MWBE company in an industry like mine, construction management, the current law would make my situation worse. I already have to pay more than majority-owned firms for qualified job candidates because competition for talent is very tight. If I publish a maximum salary for an engineer, my large majority-owned competitors can easily outbid my offer. This will push salaries up, which may be good for job candidates, but not for business owners like me. I think there are 4 better ways to encourage pay parity without hurting small and mid-sized employers like myself. When I bid for a contract in New Jersey, for example, they require that I comply with AA 302 reporting statute, where I provide information on the race and gender of my employees. A similar form for the city of New York can be modified to add salary by race and gender to such a reporting form that companies could file annually or whenever a city contract is awarded. This is the approach that President Obama took in his executive order that required companies with more than 100 employees to submit to the EEOC. If the council has consulted with employers before enacting this law, I think we should have proposed better solutions. I support the amendments recommended, but they do not go far enough to protect people in my situation. Thank you.
Thank you, Barbara. I would just like to acknowledge we have Council Member Salamanca who's joined us today. Next, I will be calling Tim Johnson, followed by Jessica Walker, and then Gloria Middleton. Tim, you can go ahead when the sergeants call time.
Your time starts now.
Chair Williams and members of the New York City Council Committee on Civil and Human Rights. I am here representing the Greater New York Hospital Association. We represent and include in our membership all the hospitals, both public and voluntary in the city. All of our members are not-for-profit. We also work very closely with community-based organizations, community health centers, and we are concerned that Local Law 32 as written may harm the ability for hospitals, those other healthcare organizations, and others to be able to recruit from the widest talent pool that they have available if the law is implemented as written. I agree with Barbara that some further amendments are necessary. And right now we are facing in the state of New York, including in the city of New York, a healthcare staffing crisis. The governor of New York has put forth executive orders and declarations around healthcare staffing. And I think that it's very, very important that our safety net hospitals, the other healthcare organizations, are able to draw upon the widest talent pool that they can. And I think that Local Law 32, and even with Intro 134, has the potential to reduce that talent pool of available people applying for these jobs. When I hear the Deputy Commissioner earlier saying that one of the benefits of this law is that folks can look at it and decide, is this a good fit? I don't necessarily want people to look at it and rule out healthcare jobs. I want more people to get in and allow those organizations to have the opportunity to really make a case that these mission-based organizations that may not pay as much as a lot of other organizations are actually a great place to work. And I would really be looking for a further amendment such as to require employers to disclose salary ranges at conditional offer or something like that. But we're happy to work with the council. I would also note in closing that most of the healthcare jobs in the city of New York are subject to collective bargaining. They have been negotiated between unions and employers. And I would just ask you to take that into consideration in thinking about further amendments. And I'll stop there. Happy to answer any questions.
Thank you, Tim. I will actually now call on Councilmember Faria to ask any questions she has.
I initially had my hand up when we were receiving testimony from Barbara Kushner. If she's still on, could I ask the question?
Yes, Councilmember, she's still on.
Great. Thank you so much for testifying earlier. You said something that I just have a clarifying question on. You were making a comparison between a New Jersey law or a compliance law that you have to file with your business over there, and stating that by breaking down the race and gender of your employees, it shows comparatively the salary ranges that you are then paying each of those people. Did I understand that correctly?
Not quite, Council. I'm sorry about that. Not quite. what it does do right now, that is a form that we fill out. It's called the AA 302 with the Department of Treasury for the state of New Jersey. And that form allows you to break down gender, ethnicity, the number of African Americans, Asians, whatever in your company. And you have to list the number and what office they're located in.
Okay.
It does not ask you about pay or anything like that. I am saying that this is a typical form that can be used and modified to include the pay range or the, if you've got, so for instance, one Black person in that office, and there won't really be a pay range. You're going to have to put that person's pay down there.
Okay.
So there are different ways to handle this.
Sure. So, I mean, in New York, we do not have that same
right.
right now. So that, regardless of it, maybe New Jersey should make a change for their salary ranges to be included. Right now, we don't have anything like that. So comparatively in New Jersey, we can't say you as yourself has 3 Black employees and 1 white employee, and the white employee is getting paid more than 2 of the 3 Black employees. And I think that's the reason why we need the salary ranges, because what we're talking about here is the inequity in salary, right? And posting a position and being able to say, I have full autonomy in applying for a job with your construction company because I'm saying I could totally do whatever they're asking me for on this job description with the full list of duties and responsibilities within that range of the minimum and the maximum. I feel comfortable every single day going to work within that salary range because that's where I feel I'd be willing to get paid for. So I just wanted to make sure that in New Jersey, maybe they're ahead of the game on us and being able to do that, but that's definitely not the case. Okay, just wanted to clarify that. Thank you.
Just to respond to that, a salary range will only do so much for an employer. Like for instance, I just advertised for a controller on this platform called Workable, and I get people through Indeed or Monster, and I have a salary range there from $90,000 to $125,000. So I get in resumes. I take a look at those resumes, and then I evaluate that person to see if they are adequate based on their credentials for that job. At that time, I'm not even thinking about salary. I'm thinking about the credentials of what I need. So I don't want people to assume as an employer that if I was a white, Asian, whatever employer, Hispanic, Latino, that I am discriminating, because I'm looking at the person's qualification right off the bat, not what I'm going to pay them. I want that good qualified person.
No, 100%, absolutely. And thank you for already doing that. I myself as an employer make sure I have salary ranges too, because I don't want people to feel like, one, they cannot do the duties that are listed at a range that they're uncomfortable with for salary, but also, so there is a level of expectation set that there are standards or there are minimum standards that I'm looking for in a candidate, and those people should be self-selecting in to apply for that. So I agree with you in that sense. I'm glad you're already complying and you're doing that for folks in the community who want to work for you as an employer. I appreciate your testimony. I just wanted to get some clarifying points on why I personally feel like the salary ranges on job qualifications and requirements are essential.
Thank you, Council Member. Seeing no other questions, we will now welcome testimony from Jessica Walker, followed by Gloria Middleton, and then Beverly Neufeld. Jessica, you can go ahead when the sergeant's call time.
Time starts now.
Hi, thank you. I'm Jessica Walker, the president of the Manhattan Chamber of Commerce. We are a business organization, and since COVID started, we have been going door to door to try to help as many small businesses survive as we can. First, I just want to say we are still very much in COVID recovery mode with a lot of these small businesses. There's still a lot of pain and a lot of debt that many of them have taken on. So we are very concerned about about where they are. So let me just start there. I support the bill before you today, even though I totally understand the aims of what you're trying to do, but I do think that these changes are needed, particularly to help small businesses right now. We have done, like I said, going door to door, we've done hundreds of webinars during COVID to try to educate small businesses on all the different laws that have come out, the different mandates, but there is just so much confusion. And so this would be another law that not only would be very confusing for a lot of businesses to implement, because many of them small businesses do not have an HR manager. It's usually the small business owner who's implementing a lot of this. And it's a hardship and opens them up to a lot of lawsuits if they don't do it correctly. So that's why I think it's really important that we do support the move, particularly to 15 employees. Honestly, it probably should be higher, but I think that is a good start. And of course, slowing down the implementation of this, because we've really got to get the word out. There's so many things that there's laws that are already on the books that small businesses don't understand. So this is something else that can really be confusing and, like I said, open them to lawsuits. Thank you so much. And of course, we want to be helpful in any way that we can.
Thanks, Jessica. Can I ask you a quick question? Because I know some of the chambers typically work with different agencies. I know the Queen's Chamber always works with SBS. Has CCHR worked with the chambers to support the outreach efforts around existing employment practices?
We have hosted some webinars on different laws as they have come out. But like I said, this is small businesses are busy running their businesses, so they can only do so much in terms of coming to a webinar. And again, there are so many different laws, and during COVID, there were different mandates around different rules around sick leave and whatnot. So there was just, and of course, businesses needed information on PPP and all the other help that was available. So there was just so much coming at them, and there continues to be. So yes, we have worked together in the past, but it's, again, one drip in this big ocean of all the things that small business owners need to know about.
And how would you respond to concerns that large employers will use general listings to avoid salary postings?
Well,
I know you work with a different range of businesses in the chamber.
Yeah, I think that Kathy Wilds really addressed some of that in terms of that there are different, sometimes you need to be able to explain that. We're a nonprofit. I work with a lot of different nonprofits, and I know that, for example, they get different grants that have salary lines that are sort of built into those grants. And it's a little hard for other staff members to see that when you really don't have full control over it. So, there are some legitimate reasons why that can be, difficult for a business to do.
Thank you.
Seeing no other questions, I would like to now call on Gloria Middleton to testify, followed by Beverly Neufeld, and then Devi Priya Chatterjee. Gloria, you can go ahead when the sergeants call time.
Time starts now.
Good morning, Committee Chair Williams and committee members and City Council members. My name is Gloria Middleton. I am President of Communication Workers of America, Local 1180. Local 1180 represents almost 9,000 active city, administrative, and private sector workers and close to 6,000 retirees. One of our main objectives as a union representing predominantly women and women of color has been to fight for equal salaries for all. I am here today to speak out against all proposed amendments to Local Law 32, as they are dangerous and will fully dilute the intention of the new law that is scheduled to take effect on May 15th. By requiring all employers to include both the minimum and maximum salaries in their job postings, Local Law 32 simply does what should have been done decades ago: level the playing field for women, women of color, and all minorities. Far too many times I have heard too many women tell me she left a job interview where she was asked what salary she was expecting, only to sell herself short by suggesting an amount far below her actual worth. The wage gap between white men and women of color earnings continues to rob a clear sector of workers of fair wages and the economic stability to support themselves and their families. In the year 2022, we should long be past the point of even having this conversation. Yet here we are fighting to stop any interference in the progress we are finally making to close a wage gap that has hurt so many far too long. I am strongly urging the entire City Council to vote against any changes or amendments that are aimed at creating loopholes for businesses. There is nothing difficult about stating your salary range in a job posting, unless you are trying to do something devious. Local Law 32 is perfectly suited to helping stop the destructive wage gap and has already wreaked economic havoc on the pockets of women and minorities. Thank you for allowing me to testify.
Thank you, Gloria. Next, we will call on Beverly Neufeld, followed by Devi Priya Chatterjee and Seher Khawaja. Beverly, I believe we have two of you listed on our Zoom. So if you could just let us know which one to mute. Thank you.
There we go. How is that? Can you hear me?
Yes, that's great.
Oh,
Thank
terrific. You. Great. Thank you so very much for this opportunity to speak to you today about Intro 134. I'm Beverly Neufeld, and I'm founder and president of Power New York. We are a collective group of gender and racial justice organizations. We agree to work together because we want to achieve economic equality for New York women. We have a letter that I will put into testimony, but I'd like to use my time just in a different way, and that is to express some sentiments that our community feels right now. We started out as the Equal Pay Campaign in 2007, and for 16 years, we have worked with leaders, workers, and with businesses to find ways to break down the problem of wage equity. Every year we stand on the steps of City Hall. This year, as you can see, this was our picture. It was an enthusiastic gathering. Everyone called for a way to end wage inequity. It is commonly done. I have videos. You can go online and hear all the leaders of New York call for it. How do you do that, though, is a question. You need to take action. It doesn't happen because we want it to. And so what we've done is we've worked hard together and we passed some laws. I frankly have to say the business community has never approved of any of the laws that we have passed. They have never spoken in favor of the salary history ban, particularly. So I'm not surprised that now they are mounting an effort to not push back, but to really eviscerate Local Law 32. This law was passed. I have very little time, but I do want to point out this law was passed legitimately. It was passed with full, almost completely in favor of it. These are not tweaks that are being, thank you. These are not tweaks that are being proposed. These are not slight changes. These are carve-outs that are tremendous, and they really put in jeopardy everything that we have tried to achieve together. So I do urge the City Council to stand up to whatever sources are at play here and pushing us toward thinking about the needs. We're not supposed to be here. You weren't elected to think about the needs of business. We're here to think about the needs of workers. So I ask you to take that into consideration. And thank you very much for the time.
Thank you, Beverly. Next, we will call on Devi Priya Chatterjee, followed by Seher Khawaja, and then Elizabeth Velez. Devi Priya, you can go ahead when the sergeants call time.
The time starts now.
Hi, everyone. Thank you, Chair Williams and committee members for providing the opportunity to testify today. My name is Devi Priya Chatterjee, and I'm a senior economist with the Community Service Society of New York, a nonprofit organization that works to promote economic opportunity for New Yorkers. We have championed workers' rights and poverty alleviation for 175 years. Most recently, we worked to pass paid sick leave laws statewide and in New York City, secured half-price transit fares, and made rent relief available through ERAP alongside our coalition partners. My testimony today will focus on Intro 0134 and how this bill would render the salary range transparency law legislation that was passed already toothless, and thus undo years of work towards achieving pay parity along racial, ethnic, and gender lines. My fellow advocates of pay parity have already shared information on the problem that we are hoping to address by the salary range transparency law. So this law requires employers to post exactly that, a range, a maximum and minimum level of salaried compensation that an employee can be expected to receive. It's not an alien concept. Most corporations, nonprofits, most importantly, the city of New York does it. Numerous studies have shown that greater transparency reduces pay inequities, typically by empowering women and, most importantly, women of color to negotiate better wages. Intro 0134 wants to exclude employers with 5 to 15 employees from having to declare the salary range. In the name of helping small struggling businesses, the current bill is impeding progress towards pay parity. There are about 58,000 of these businesses per data from New York State's Department of Labor. These businesses employ around 500,000 workers and have an average annual payroll of $550,000. By excluding these businesses, the city would imperil over 222,000 women workers who would once again apply for jobs without any idea about salary. Opponents of the original salary bill have required that the businesses, by having to post the range, would be anti-competitive and might hurt employers' chances of attracting talent. But there are ways of beefing up compensation beyond the salary range by providing perks, stock options, bonuses, etc. And I would just like to say that given that women still earn only 83 cents on the dollar relative to men, it is more important than ever to address pay parity in a tight labor market. This is the best time for workers.
Thank you.
Thank you.
I have a quick question. Where did you said you got your data from New York State, but can you explain exactly what the data says, and was it specific to New York City, and how did they define small businesses? Did they have a number of employees?
Yes. So the data has been, that was made available to me by the New York City Department, New York City subdivision of the New York State Department for Labor. They go into the quarterly census of employment and wages, the QCEW data, and filter out all the businesses that employed from 5 to 15 employees, all the establishments that had 5 to 15 employees, and provided annual wages and the annual and the total number of establishments that did that.
And they pulled data from which years?
This is the last 4 quarters. The last 4 quarters. So they gave me these numbers and the gender number that I shared with you. So it comes from using the American Community Surveys, which publishes the gender makeup for each industrial sector. So like finance is 45% women, and construction is 27% women. So when you take these percentages and employ those on this kind of breakup that the State Department of Labor provided, I get around 222,000 women who would be affected. I could have also generated these numbers for different races, like workers of color and so on, but we didn't have time for that before the testimony. Thank you.
Thank you. Seeing no other questions, I would like to now welcome Saher Khawaja to testify, followed by Elizabeth Velez and John T. O'Malley. Saher, you can go ahead when the sergeants call time.
Time starts now.
Thank you and good afternoon. My name is Saher Khawaja and I'm a senior attorney within Momentum, the Women's Legal Defense and Education Fund. For over 5 decades, we have been at the forefront of using the law to advance gender equality, and it is with that expertise that I am testifying today to propose Intro 134. Last year, New York City enacted Local Law 32, a pay transparency law that we believe will have a transformative impact in advancing pay equity in New York City, particularly for women of color who have been left behind. Research cited in our written testimony amply demonstrates that this approach helps tackle unconscious bias, gives women of color much needed leverage, and drives employers to pay more equitably. Intro 134 and its seemingly innocuous amendments would obliterate this impact by excluding a large sector of New York City workforce from critical equal protections would create loopholes that would allow a large number of employers, big and small, to avoid compliance altogether, and establish a scheme that would create inequity among employers and roll back our progressive worker-centered human rights law. Intro 134 attempts to expand the existing small business exemption from 4 to 15 employees, taking us backwards. Recent successes to expand protections to domestic workers and to all victims of sexual harassment have brought us closer to a critical truth, which is that every worker in New York City deserves the protection of our human rights law. Each time we expand the employer thresholds in this way, we tell more workers that they are not entitled to anti-discrimination protection simply because of the size of their employer. And what we know is that a significant number of workers who will be excluded are exactly the people this bill was meant to support, who the Council has vowed to advocate for: women of color in low-wage work. Excluded businesses would likely include hair salons, nail salons, daycare providers, restaurants, and retail stores where women of color are overrepresented, typically make lower wages, and would benefit significantly from knowing rates of pay when applying for jobs. The claim that small businesses are competitive because they can conceal pay rates inherently suggests that small businesses succeed based on underselling workers, which I do not believe must be the case, as we know of women and minority-owned businesses that already disclose pay rates and are thriving. Small businesses have much to gain, alternatively, from pay transparency, including efficiencies in retention, job satisfaction, and trust. As more businesses disclose salary, this information is going to be out, and small businesses need to be equipped to make this shift rather than to avoid it. If we're going to protect women of color in our workforce, we must recognize that strategies to protect small businesses can no longer be pitted against or be at the expense of large number of women who work for these small employers, many of whom endure some of the worst forms of exploitation in our experience. In lieu of these problematic exemptions, we recommend extending the enforcement date and providing training, outreach, and guidance, as the Commission is already doing.
Thank you, Sahar. We would like to now call on Elizabeth Velez to testify, followed by John T. O'Malley, and then Mary Luke. Elizabeth, you can go ahead when the sergeant's call time.
I don't think that the administration is currently doing any outreach, because when we spoke to them during their testimony, they mentioned like this is something that they're gonna do. So I just wanted to clarify that point. So I don't think they're doing any outreach, which I think is a part of the problem. But I'm sorry, the next person can testify.
Time starts now.
Hi, my name is Elizabeth Stone. I'm a restaurant server in Park Slope and a member of the Restaurant Opportunities Centers United. I've been in the food service industry for over a year, and I've been working as a server in New York City for 6 months. As someone relatively new to the industry, I've found that one of my biggest obstacles to job security is the lack of salary transparency in job postings. At my current position, I was offered a flat rate of $10 an hour with no transparency regarding a salary range or expectations for future salary growth. As a financially independent young adult, it is extremely unsettling and difficult to feel secure within such an unstable standard. Recently, I've begun searching for new positions in food service and have experienced a myriad of inconsistent, uninformative job postings. I feel stuck in my position and scared to move forward to an employee that may ultimately pay me less. On top of this, I feel that I have no bargaining power to persuade my current employer to pay me more as opposed to leaving for a different position. Most postings I have encountered state simply the minimum wage, if anything at all, despite the increasing demand for servers in the upcoming summer months. Especially as a waitress with New York City experience, I know my skills are valuable, yet I constantly feel a lack of security or bargaining power. If employers of small restaurants would simply post salary ranges, I would be able to financially plan, reduce stress, and make ends meet. At the end of the day, I believe I deserve to know how much I can make as a waitress in Brooklyn. Thank you.
Thank you, Elizabeth. We will now call on John T. O'Malley to testify, followed by Mary Luke, and then Linda Hartley. John, you can go ahead when the sergeant's call time.
Time starts now.
Thank you, John O'Malley. I'm an employee in New York City. Fairness, leveling the playing field, and prohibiting discrimination. These are the principles that we're striving to improve with this policy. Consumers get a better deal when they know the value of the vehicle before they go to the dealer to negotiate. Unions get a better contract when they know how much the employer can afford before they negotiate the contract. Defendants get a better deal when they know what evidence is against them before they conference with the prosecutors. And job applicants get a better deal when they know the wage range before they are interviewed and negotiate. In order to achieve the fairness we seek and prohibit discrimination, we must require that the party that has the information to disclose it to the party that does not have the information. In all these examples, there's a process of requesting information and a requirement that it must be provided. And currently, under the New York City human rights law, employers must list the wage range on the job posting before the interview and in good faith. As far as I know, nobody's attempting to hide the value of vehicles, and nobody's trying to roll back the regulations requiring disclosure of information on union negotiations. But prosecutors have been complaining recently about the new discovery rules that have increased their workload. But we have to inform the accused of the evidence against them. And while there could be some pressure to roll back those advances, one attorney from legal aid cautions against this, saying it cannot be the case and must not be the case that the way you solve a workload problem for the prosecutors is to diminish the rights of somebody accused of a crime. Intro 134 seeks to roll back the requirement to disclose wage range for over 90% of workers in New York City. That's over 4 million workers. The New York City Council established that it's discriminatory to withhold the wage range information until after the interview, that the employer should provide a good faith range that they believe to be true on the job posting. This is critical because once interviewed, the employer may adjust the wage offer based on the applicant rather than the job. This is counterintuitive to your stated purpose. Modeling the words of the attorney from the Legal Aid Society, it cannot be the case and must not be the case that the way to solve discrimination problem is to diminish the number of people covered by the law. I hope that you agree, and I hope that you will not pass Intro 134. Thank you.
Thanks for your testimony, John. What type of business do you run?
I don't run a business, I'm an employee.
Oh, you say you're an employee. I thought you said you were an employer. Okay, thank you.
Thank you. Seeing no other questions, I would like to now call on Mary Luke to testify, followed by Linda Hartley, and then Solange Charis. Mary, you can start when the sergeant's call time.
Time starts now.
Thank you very much for this opportunity. I'm Mary Luke, and I'm Vice President of UN Women USA, which is an NGO, and also with Power New York. I appreciate this opportunity to speak against Intro 134. New York City plays a unique role on the international stage because it is home to the United Nations. And I'm so proud of New York City's historic role as a model sister city and safe cities, and one of the first cities to pass the salary history law. Local Law 32 is another example of New York City's leadership position supporting gender equity. This is a step towards gender equity. It's not the whole thing, not any law is the whole thing, but making changes to diminish this law, which is a model for promoting salary transparency in hiring and promotions, even before it's implemented, would be an embarrassment for a progressive city like ours. I want to speak about the amendment on exempting employers with 15 or fewer employees, and also the general help wanted ads, which often are directed towards immigrants. I speak as a first-generation Asian American raised in a Chinese-speaking household with parents who worked in a restaurant. When I started my professional life as a nurse and a researcher, I was totally clueless about wages, workers' rights, and furthermore did not even think it was appropriate to ask about such things. Many immigrants now, especially those newly arrived, have limited English and education and can easily be exploited. They often start out and remain in low-wage jobs such as beauty salons, restaurants, service workers, care workers.
Time expired.
These are some of the minority women-owned businesses that would be exempt under Intro 134. It's more important than ever that workers, all workers, have under Local Law 32 have access to salary range information so they can start their work life and advance in their jobs, knowing they will be paid fairly and equally for work of equal value. Thank you very much.
Thank you, Mary. I would like to now call on Linda Hartley to testify, followed by Solange Charis, and then Nicholas. Linda, you can go ahead when the sergeant's call time.
Time starts now.
Thank you.
President John Kennedy signed the Equal Pay Act into law in 1963, saying the new legislation would end the unconscionable practice of paying female employees less wages than male employees for the same job. I'm Linda Hartley, principal and business owner of H2 Growth Strategies. With a team of 8 consultants, we have partnered with over 100 nonprofits to raise more than $1.5 billion. I serve as a board member of Power New York and am co-author of Big Impact about leadership and social change in the nonprofit sector. So here we are, nearly 60 years after the Equal Pay Act, and still millions of dollars are lost to women in their careers every year due to pay inequities. I have a relevant story to share. Early in my career, I joined a major New York university where I performed well and was promoted several times while completing an MBA at night. My boss told me many times my performance was far superior to the older man who had held the job before me. Then a female colleague, risking her own job in sharing wage information, told me I was being paid 20% less than my male counterpart. It took nearly a year to argue for and obtain a 10% increase, only halfway toward that 20% difference. So just looking at that year's difference, if you take the initial $7,500 lost due to pay inequity and invested it at 7% over 40 years, the total loss is $112,000. A wage transparency law back then would have enabled me to negotiate for a higher starting salary and higher raises based on my performance. The New York City salary range law is a model for the state and the country, empowering workers and leveling the paying field for all workers. I urge the Committee on Civil and Human Rights not to gut the bill with proposed amendments. It has been nearly 60 years past time to end the unconscionable practice of paying women less because we can. Thank you.
Thanks, Linda. I have a quick question. So the story that you shared about your own pay inequity issue, how do you think that pay transparency would have addressed the issue?
Well, when I was hired and I had known about the pay salary, I would have negotiated a higher starting salary right there. And knowing what the level is, it would have at least inferred that there was perhaps someone that was being paid more for that job before. And for someone that's in the job already, if you're looking at ads that your employer is sending out, of course you'll know then about where you fit in that pay range, whether you're getting paid. So it's going to be helping anyone, even who's already employed, because they're free to look at salary ranges as well when the employer sends out ads.
But there's no guarantee that you would get the higher range or the lower range, because they still could technically negotiate down and discriminate.
Yes, and that 20% difference could have been right within that range. You're right.
But I do get the point, but I think that some of the testimony today is heavily skewed, in which I understand, because you have to make this particular argument because this is the thing that is being amended, but it's heavily skewed to a particular sort of activity around disclosing salaries on job descriptions, but there's really no way for us to determine whether or not women will still be, or people of color will still be discriminated against if they get the lower bottom half of the particular salary range. So I was just thinking about that. And I was thinking about something that I think Barbara said about the New Jersey law, which I think actually makes a lot of sense, because my thing is, like, to your story about the woman who told you and shared the salary, that to me is like more of the issue, because even when a person is hired, if they gave a woman the lower salary, there's no way for people within the company or the job or whatever the makeup of the business is to know who's getting the higher range or the lower range unless people are having the conversation within the office. So, I mean, I think, again, this is a great first step. And I understand that this is important, but I do feel like it only goes to a certain limit, because there's still no way to determine whether or not there is a pay equity issue just because you disclose a salary on a job description. And I don't disagree with that. I'm just saying there's no way to really determine how much a person is getting paid unless you're like us in city and state government, where the salaries are for public information. That is really the only way to say, okay, well, we've done an inventory and we see that most of the women are getting paid this, or most of the Black folks are getting paid this and others are getting paid that. There's no way to really compare. And so I'm making that point to say, while this is an important measure, I think that we are focusing on one side of the table and not the full scope of what actually addresses pay equity. So I was just wondering your thoughts.
Yes, yeah, just 2 points, and you've made some very good points, and we have to go further. This is a step in the right direction, the full law, and it allows people, I think especially women, if you've got the salary range and you're interviewing for a job, you can negotiate for a higher starting range. It helps you do that.
So I understand that point. I just wanted to, I think it's important, and this is just me, right? If I'm having one conversation, I want to have a comprehensive conversation. And so I think a lot of the testimony is focused on like one particular aspect that will help to address pay equity, but we're not talking about the totality of the issue. And so I just wanted to bring that into the conversation, but I appreciate what you were saying. And I see all of these hands, and I wish that you all would have engaged in conversation with me before the hearing instead of being on the hearing and engaging in conversation with me here. But we can go to the next person who is supposed to testify.
Thank you.
Thank you, Chair Williams. I do see that Councilmember Farias has her hand raised. Councilmember, you can go ahead.
Sorry, still figuring out the unmuting situation. No, I just thought what Chair Williams was stating, I just wanted to follow up and say, like, yes, and it sounds like you have more bills to put in, because I think Jersey definitely needs to step their game up, but it would be great for us to have some salary transparency bills come up in the past. We've tried it and it hasn't worked, but maybe this is the council where we can put some of that up and see the push, because I think what you're saying is critical to the larger conversation that needs to be had around salary transparency or wage equity transparency. And I think that this intro, particularly what we're seeing with amendments, is going to exacerbate some of the very issues that we're bringing up here, because of all of those issues. I think that's why some of the testimony is hyper-focused, is because we do not want it to be exacerbated and continue on. But I'm happy to keep working on some bills to get more transparency out there with you, Chair. If
yeah, and we should talk offline. I know we were supposed to chat, because I'm want to have this dialogue, and I'm happy that we actually are having hearings where there's dialogue, because that's not something that I've seen in the past as a person who's worked in government, but I'm a person that likes to have dialogue, and hearings don't always offer the opportunity to have full dialogue, because you want to get your few talking points and then it's over, right? And then we want to respect everybody's time, so we don't want to go back and forth on a public hearing. And so I get what you're saying, and I don't disagree with what you're saying at all. I just think that we need to have a comprehensive conversation, and
100%.
not to just focus on one particular thing. But I do hear all of the concerns. Before the hearing, heard the concerns, and I'm sure you can ask committee counsel, the tons of things that I have asked and have expressed concerns with. But I think it's important that we at least have the deliberation and hear from all of the sides, and figure out what is the best way to move forward with the existing law and making amendments to the law.
Yeah. No, I just wanted to say I'm here to support, and I hear you on the additional stuff we need to do. But yeah, I can yield time. Thank you.
Thank you, council member. We'll now turn to testimony from Solange Terrace, followed by Nicholas Natoli, and then Miguel Rayos Velasquez. Solange, you can go ahead when the sergeant's call time.
Time starts now.
Thank you, Chair Williams and council members. My name is Dr. Solange Terrace, and I'm a human capital subject matter expert with a PhD in management, an MBA in accounting and finance, and a BA in economics, and 30 years of experience as a corporate executive and expert compensation consultant. Chair Williams, as a comp expert, I'm happy to talk to you about how companies manage salary ranges, salary administration, merit increases that prevent substantive gaps in pay for same level jobs, but in a different conversation. I am here to talk to you about the benefits of Local Law 32 as passed without amendments, having already highlighted how many have already highlighted how any amendments will take the law off its original intended course. In the past, I have testified in support of Local Law 32 on how pay transparency benefits employees, organizations, and the community at large. But today I want to provide you information about how this happens. This issue has been studied by the academic community for decades, and research proves that there is a positive correlation between human capital transparency and profitability for all businesses, large and small. Transparency is the solution to address the negative effect of information asymmetry. This is a theory that was posited by Joseph Stiglitz, who won a Nobel Prize for this topic. What information asymmetry is, it occurs when one party has more information than another that generates inefficiencies in decision-making to the detriment of the party with less information, in this instance, the employee. And in the aggregate, the overall impact is gross economic inefficiencies. Decades of research, the most recent from Harvard, shows that pay transparency actually benefits organizations and employees. Don't be fooled into believing that transparency will create a hardship for small companies. It is simply not true. And having been at all levels of the organization, I can denounce those who say otherwise because of their fear or uninformed opinion. The days of trade secrecy as a competitive advantage related to human capital are over. They never worked anyway. And the world is moving in this direction. Let's not let New York be behind the times. The world is watching us. Thank you for your consideration.
No problem. Can you share the research you've done around this topic specifically?
There's a whole body of research on the area of transparency. It actually shows.
Did you do any research around this topic?
I am not a principal researcher in the area of compensation. I'm a principal researcher in the area of corporate governance, ESG. And this issue is big in ESG. Everyone's looking at it from the World Economic Forum on a global basis to what's going on with the SEC. And what I am an expert in how human capital impacts the social governance for board governance and disclosure. But as a compensation consultant, I've been a practitioner in this area for 30 years. I don't research it, I practice it. What I research and what I consult in is corporate governance.
Okay.
But I have a body of academic articles that I'm very happy to share with you. Again, the most recent is a woman who's just getting her PhD at Harvard who has shared her research with me around pay transparency. And I'm happy to share that with you if you'd like to see it.
I would love to see her methodology, who she interviewed.
Her name is, her last name is Adler. And I am waiting, actually, she's just defending.
Adler?
Yeah. Her first name is Laura Adler. She's getting her PhD from Harvard, and her whole dissertation is on pay transparency.
Oh, so she has not published yet. Her current existing research is, her dissertation is going to be on that.
She's earning her PhD on this research. So in fact, it has higher level of scrutiny than any academic article. And
So I'm in a hold up. I'm in a PhD program, so I understand the scrutiny. That's why I was asking. Like, she didn't publish an article yet. It is a part of her dissertation research.
yes, which she is defending this month.
Okay.
So, and she promised to share her dissertation with me. With her consent, I'm happy to share it with you, or I'm happy to put you in touch with her.
Sure.
You can get it from the horse's mouth.
Sure, I would love to talk to her. And you said something else. I'm not fooled by anybody. I genuinely am listening to all of the concerns from the people that both oppose and support the legislation. So I don't sort of have one sway over the other. It is my bill. And so, of course, I have the obligation to defend the bill, but that does not mean that I am not flexible. And that does not mean that I am not listening to the many concerns that were raised today and thinking very intently about how we address the concerns that were made. So I just also wanted to note that.
Thank you. I appreciate that. And I'm sure you, as an academic and as a PhD candidate, you understand how critical prior research is in terms of understanding and supporting an outcome. And there is an overabundance of research that shows that transparency is a much better approach than trade secrecy. So, you know, what we find in the academic community helps inform the decisions that business people should make. And they often don't look at the academic community because, you know, ivory tower versus everyday business. But
when I wrote my essay to get into the PhD program, what I specifically spoke about was the fact that the academic world often doesn't work in conjunction with the government and policy world to be more intentional and thoughtful. And so this is why I asked for the research, because I really do want to look at the research. And if there's any other articles or books or studies that you want to share, I'm open to that. A lot of the stuff that I saw that came out from PowHer, really, there wasn't anything that was attached to research. It was just sort of bullet points. Not that you don't have research, but I didn't see the research attached to a lot of the advocacy that was being put forth. And so I would love to receive that and read about it.
Yep,
I'm totally open to that.
And hopefully somebody at PowHer will help me figure out how to get you the documents, or I'll send it through PowHer to you. So Chairman Williams, Chairperson Williams, if I can't reach out to you directly, it'll come through PowHer.
Yeah, my email is very simple. It's just nwilliams@council.nyc.gov. It's very easy. Very easy to read.
Like
my name, Natasha Williams@council.nyc.gov. I'm like very accessible.
Council.nyc.com. Okay, I will send you .gov. Sorry, I will send you stuff. And just before I get out, because I'm already late for my next meeting, where I got my PhD, our PhD is a scholarly practitioner focus. So everything that we do in the PhD program.
I love practitioner focuses.
There you go. Thank you very much for your time.
Welcome.
I appreciate your attention.
No, you're welcome.
Hi.
Thank you.
Hi.
For waiting. I know you're like one of the last people. So thank you for your patience and waiting and listening through all of this.
It's worth it.
Thank you, Chair, and thank you, Solange. I would like to now call on Nicholas Natoli, followed by Miguel Rios Velasquez, and then Miriam Clark. Nicholas, you can go ahead when sergeants call time.
Time starts now.
Hi, I'm testifying today as a resident, an individual resident. I come from District 3 in Manhattan. Last October, I was the victim of a violent hate crime in which the attacker who performed this act is now charged with felony. I think we can all see that the crimes in the city are abundant, and petrifying, detrimental to the overall well-being of everyone. Last year, terrorists opened fire on Israel, sparking a rise in anti-Semitic crime. And last week, Israel found 11 innocent civilians murdered by Palestinian terrorists. A CUNY student led group came together to call for a globalized intifada. This is very concerning for me as a human, but also as a Jewish constituent of New York. And she had lists of Zionist organizations that she was handing out. Again, violence against Jewish people continues to rise. We're just wondering, what is the Council of Human Rights doing? Where is their focus as these rates continue to rise? Like, what's going on now? What can we expect? When can we expect results in the future? And I'll yield the remaining of my time to open up the discussion for you guys.
Thanks, Nicholas. I would love to follow up with what you discussed offline to see if we could address some of the issues that you flagged.
Thank you. Thank you, Chair. Next, we have Miguel Rios Velasquez, followed by Miriam Clark. Miguel, you can go ahead when the sergeants call time.
Time starts now.
Here, it looks like we do not have Miguel in the Zoom. Accordingly, I will call Miriam Clark. Miriam, you can go ahead when the sergeants call time.
Starts now.
Thanks. I am Miriam Clark. I'm a lawyer representing employees at a small law firm, the legislative committee chair of NELA New York, which is an organization of employee lawyers. And I just wanted to speak briefly about the connection between this bill, which is a start, and by this bill, I mean Local Law 32, and pay transparency and the larger question of equal pay as I see it in my practice. So here are some examples to answer your question, Chair Williams, or in part, I think about how a bill, even at the beginnings of it, a start like this, can really affect people's lives when it comes to discrimination. So for example, if a person is working in a position, I've had many clients, especially women and people of color, who were told that they can't get promotions. They can't get salary increases because they're at the top of the salary range. This was not something that they knew when they took the job. Had they known it when they took the job, they might have looked elsewhere, because being at the top of the range is another way of telling somebody you're not going to get a raise, you might never get a raise. Now, sometimes it's actually true that there was a salary range and the person was at the top of it, but sometimes it's not true. They're not really at the top of the range. The employer just doesn't want to give that person a raise. And I think we know historically that it is white men who tend to benefit when there is a lack of transparency. That's why we have these huge salary gaps that others have referenced. So transparency around salary ranges has a profound effect on women, people of color, others who have less bargaining power to start with, or who have been the victims of either deliberate or not deliberate opacity. I just also want to say that the CCHR FAQs, which I've read, are very clear and helpful. That my understanding is that the CCHR does trainings multiple times a month, both virtually and live in every single borough. And these are directed towards small businesses. And I have to say, the small businesses of the city of New York have stepped up incredibly well when it comes to complying with the human rights law. And I'm confident that they can step up and comply with this as well.
Thank you, Miriam. Councilmember, we do not have any other witnesses. Do you have any questions you would like to ask?
Nope. I just look forward to working with all sides of this argument to ensure that we continue to protect all workers, but also keep in mind some of the concerns that have been expressed by the business community. And I am very thankful to have so many people come on and express their thoughts, concerns, support, opposition of Intro 134. I also just want to again thank the speaker and her leadership for, again, allowing us the time to have these conversations. When I sort of, as a new council member, sort of seeing a lot of the advocacy around this particular bill, the first thing that came to mind was, as advocates, we're so used to sort of having to call Hail Marys because oftentimes the voices, our voices are not heard within this space. And that is not the intent here. It is also not the intent of this legislation to gut or, eviscerate any of the wins we saw during last year when it was originally passed. And I just welcome continued deliberation and conversations around this so we can make sure we get to a place that everyone's okay with. Maybe you won't love it, but everyone is okay. And I think that's what's most important. Beverly, I do see your hand is raised. Welcome the opportunity to talk with you offline. I did try to reach you the other day. And so again, looking forward to chatting with you. And thank you for your advocacy and organizing everyone to join today.
Thank you, Chair Williams. If we have inadvertently missed anyone that had registered to testify today, please use the Zoom raise hand function and let us know. Seeing no raised hands, Chair, I think we are all set to close out this hearing.
All right, thank you so much. And I just gavel out, correct? Thank you.